25CR 001570, 25CR 001571, 25CR 001572, and 25CR 001573. In the 1450 case, there was a 2-count information filed. Oh, I apologize. Defendant is present at open court today with his counsel, William Watson. In the 1450 case, a 2-count information was filed on November 3rd of 2025. Those counts being grand theft of a motor vehicle, felony of the 4th degree, and theft of felony of the 5th degree. In the 1570 case, a 2-count information was filed on November 10th of 2025. Those 2 counts being grand theft of a motor vehicle, felony of the 4th degree, and misuse of credit cards, felony of the 5th degree. In 1571, there was a 1-count information filed on November 10th of 2025, that count being grand theft of a motor vehicle, felony of the 4th degree. In 1572, a 1-count information was filed on November 10th of 2025, that count being grand theft of a motor vehicle, felony of the 4th degree. And in 1573, a 1-count information was filed on November 13th of 2025, that count being grand theft of a motor vehicle, felony of the 4th degree. It's the state's understanding today that the defendant will waive his right to indictment in all 5 cases, that he will plead guilty to each count and each of the informations, that we will ask to defer sentencing so that a pre-sentence report, psychological evaluation, and victim impact statements may be ordered. There's no sentencing agreement. The 4 cases in the 1500s are all secret information, so they do have an additional document for booking.
Which ones are those?
1570, 1571, 1572, and 1573.
Well, aside from 1450.
Yeah, 1450 is the only one that was a bind over. They're all informations, but the 1500
So why weren't these all just done one information? Why weren't these just done in one information?
They came in at different times, as well as they came in from different departments.
They're all filed at the same time.
There are 3 different file dates for the informations.
Like, how long apart?
The first one was November 3rd. The last one was November 13th. Since he was in jail, the initial one as well was a time concern. There's no sentencing agreement.
Mr. Watson, is that all accurate?
Thank you, Your Honor. May it please the court, that is my understanding of this morning's hearing. I have had ample opportunity to discuss all of these cases with Mr. Hudson as they came in. He has indicated to me that he is prepared to enter a change of plea by way of information as just outlined by the state. First, Your Honor, for each respective case, my client does understand that by entering a plea by way of information, he is going to be waiving his right to have these respective cases presented to the Lake County Grand Jury. Furthermore, for all the cases, my client understands that by entering a change of plea, he will be waiving certain constitutional rights, and no threats or promises have been made in order for him to do so, Your Honor.
Thank you. You said there were secret informations?
Yes, the 1570, 71, 72.
But then how were they bound over?
No, 1450 was the only one bound over.
So the other ones didn't get bound over?
Correct. I believe I said 1450 was bound
Right.
over. So he was in jail.
So the other ones just were sent, police reports that were sent to your office directly?
Yes, as they came in. They did not all come in on the same dates.
They all came in within 10 days of each other?
Because the state contacted the police departments to have them sent over as secrets to try and get them as close in time as possible.
Mr. Hudson, were you able to hear what the prosecutor and your lawyer just had to say regarding what they believe your intentions are here this morning?
Yes, sir.
They've indicated to the court they believe it's your desire in each of these 5 cases to waive your right to have the case presented to a grand jury, and I'm going to explain in a moment in more detail what that actually means. And then you're going to plead guilty to the charges in each of the respective informations, and I'll go over each of those with you to make sure you understand what those are as well. We would then, if I accept your plea, defer, continue the sentencing to a future day, get some evaluations completed, come back on a future day for sentencing where there's no agreement between the parties regarding any recommendations for sentencing. Each side is free to recommend to the court whatever sentence they believe is the right thing to do. Is that your understanding of the discussions that took place between your lawyer and the prosecutor and what you want to do here today regarding these 5 cases?
Yes, sir.
Well, before I can accept your guilty plea, I need to make sure you understand everything we're doing here. I need to make sure you understand what it is you're charged with and pleading guilty to, all the rights you have that you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine all those issues, I'm going to ask you a series of questions. If at any point when I'm asking you these questions, if you're unsure, unclear of anything I'm asking you, if you need anything repeated or clarified, if you'd like a moment to talk with your lawyer to ask him questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right?
I got you.
All right. Let's get started then. How old are you, sir?
22, sir.
Are you able to read and write the English language?
Yes.
Do you have any difficulty with that, or difficulty understanding what you read in the English language?
No.
Are you a U.S. citizen?
Yes.
Now, before you came into court here this morning, have you any drugs or alcohol of any kind?
No, sir.
What about within the last 48 hours?
No, sir.
Not even prescribed medication, nothing?
No, sir.
Now, did you receive a copy of each of these informations before you came in here today?
Yes, sir.
And you had a chance to look those over at some point?
Yes, I did.
Now, we'll start with 25 CR 1450. I'm charged with 2 counts. Pleading guilty to both of these counts. And what's alleged in count 1 is on or about September 29, 2025 in Willoughby Lake County, Ohio, that you did with purpose to deprive Robin Bostic, who was the owner of property, being a Chevy Impala, that you knowingly obtained or exerted control over that property without the consent of Robin Bostic, who again was the owner, or any other person authorized to give consent. The property involved is a motor vehicle, which makes the offense grand theft of a motor vehicle a felony of the 4th degree. Do you understand what you're charged with and pleading guilty to in count 1?
Yes, I do.
Any questions about it?
No, sir.
Count 2, what's alleged on that same day, September 29, 2025, in Willoughby Lake County, Ohio, that you did with purpose to deprive Anthony Tortorici, the owner of property, being a Fifth Third bank card, that you knowingly obtained or exerted control over that property without the consent of the owner or anyone else authorized to give consent. It's further alleged the property involved in the theft is a credit card, which makes the offense theft a felony of the 5th degree. Do you understand what you're charged with and pleading guilty to in this count?
Yes, sir.
Any questions about that?
No, sir.
Now, in case 25 CR 1570, again, you're charged with 2 counts. What's alleged in the first count is on or about October 1st, 2025, in Menor Lake County, Ohio, that you did with purpose to deprive Ashley Carney, the owner of property, being a 2024 Black Dodge Ram, knowingly obtained or exerted control over that property without the consent of Ashley Carney, who again was the owner, or anyone else authorized to give consent. The property involved is a motor vehicle, which makes the offense grand theft of a motor vehicle a felony of the 4th degree. Do you understand what you're charged with and pleading guilty to in count 1?
Yes, sir.
Any questions about it?
No.
Count 2, what's alleged is on or between October 1st and October 2nd of 2025 as a part of a continuing course of criminal conduct beginning in Willoughby Lake County, Ohio, and ending in Euclid, Cuyahoga County, Ohio, that you did with purpose to defraud obtain property or services by use of a credit card in 1 or more transactions, knowing or having reasonable cause to believe that the card had been expired or been revoked or was obtained, is being retained, or was being used in violation of the law. It's further alleged the cumulative retail value of the property and services involved in 1 or more of the violations, which involved 1 or more credit card accounts and occurred within a period of 90 consecutive days, was over $1,000, which makes the offense of misuse of a credit card a felony of the 5th degree. Do you understand what you're charged with and pleading guilty to in this case?
Yes, I do.
Any questions about it?
No, sir.
In case 25 CR 1571, there's one count here, and what's alleged here and what you're admitting to is on or about September 20th, 2025 in Willoughby Hills, Lake County, Ohio, that you did with purpose to deprive Davon Boyd, the owner of property, being a 2017 Black Dodge Ram Rebel, knowingly obtain or exert control over that property without the consent of Mr. Boyd, who is the owner, or anyone else authorized to give consent. The property was a motor vehicle, which makes the offense grand theft of a motor vehicle a felony of the 4th degree. Do you understand what you're charged with and pleading guilty to in this case?
Yes, sir.
Any questions
No,
about
sir.
it? In case 25 CR 1572, again, it's one count. It's alleged here that on or about August 2nd, 2025, in Wickliffe, Lake County, Ohio, that you did with purpose to deprive Joseph Costello, the owner of property, being a 2022 white Subaru Ascent, knowingly obtain or exert control over that property without the consent of Joseph Costello, who is the owner, or anyone else authorized to give consent. The property involved is a motor vehicle, which makes the offense grand theft of a motor vehicle a felony of the 4th degree. Do you understand what you're charged with and pleading guilty to in this count?
Yes, sir.
Lastly, in case 25 CR 1573, that's one count. It's alleged here on or about August 31st, 2025 in Eastlake, Lake County, Ohio, that you did with purpose to deprive William Dolan, who is the owner of property, being a 2016 red GMC Canyon, knowingly obtain or exert control over that property without the consent of Mr. Dolan, who is the owner, or anyone else authorized to give consent. The property involved is a motor vehicle, which makes the offense grand theft of a motor vehicle a felony of the 4th degree. Do you understand what you're charged with and pleading guilty to in this case?
Yes, sir.
Any questions for me?
No, sir.
So you understand the nature of the charges in all 5 of these cases?
Yes, I do.
Well, before I can accept your guilty plea, then, I need to make sure you understand all the rights you're giving up by pleading guilty. And first of all, in each of these cases, you have the right to have each case presented to a grand jury. So the documents that I just read to you are called informations. And information is a criminal charge brought by the prosecutor's office without the case having previously been reviewed or considered by a grand jury. Excuse me. Now what a grand jury is, it's made up of a group of citizens here from Lake County that get together and they meet privately. They meet in secret for the purpose of evaluating evidence in cases to determine whether probable cause exists that someone committed a crime. Probable cause is defined as some evidence that would suggest the person probably committed a criminal offense. Everyone here in the state of Ohio accused of a felony has the right to have a grand jury independently review the evidence in a case and make a decision without the government being involved in that decision, whether someone should be charged or not. You have that right as well in each of these cases, but you can waive that right or give up that right if you desire and go forward in the charges brought by the prosecutor and the information, and your attorney has indicated he believes that's how you want to proceed. Is that correct?
Yes, sir.
Well, before I can accept or go any further, I need to have you acknowledge that here in open court in writing. And I have in my possession here 5 documents, each called a waiver of indictment. There's one for each respective case that we've talked about. And these documents set forth what I've just explained to you about the grand jury process and that you want to give up that right. Before I can go further, I need to be assured you understand what these documents say, and you sign them here in open court. Now, they're each identical, except that they each have the respective charges that go along with that particular case. That could be the difference. Otherwise, they explain the same right. My understanding is that before I came out here, you had a chance to go over each of these documents with your lawyer. Is that correct?
Yes, sir.
Mr. Watson, is that accurate? Did you review each of these with Mr. Hudson, go over them with him, answer his questions?
Yes, Your Honor, I did review each waiver of indictment form individually with Mr. Hudson. I read it to him, he read along with me. He signed it, and I signed it in the presence of the prosecutor, Your Honor.
When he went through it, he indicated he understood them to you?
Yes, Your Honor.
Is that correct, Mr. Hudson?
Yes, sir.
So you understand what these documents say?
Yeah, I do.
Do you have any questions for me about them?
No, sir.
Now, it does appear, and your lawyer indicated that you signed them. Did you in fact sign them?
You said what?
Did you sign each of these
Yes, I
5
did.
documents?
Yep.
Ms. Kutch, you witnessed those signatures as well?
Yes, Your Honor.
All right, well, I will make each of these documents part of the record in each of the respective cases. At this point, Mr. Hudson, I'm going to review with you all the other rights you have that you're giving up by pleading guilty. And all these rights apply to each case. I'm not going to go over them 5 separate times. All the rights you're talking about you have for each of these cases. If there's anything that applies to 1 or more cases and not all the cases, I don't think that should be the case here, but I'll make sure I point that out otherwise. Otherwise, everything applies to all 5 of the cases, all right?
Sounds good.
All right, well, in each of these cases, you have the right to have a trial. A trial could be to me as a judge, where I listen to all the evidence and I make the decision whether you're guilty or not guilty. But you also have a constitutional right in each of these cases to have a jury trial, and that would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. The jurors would consider and weigh all that evidence, and then those jurors would make that ultimate decision. And that ultimate decision reached by the jurors would have to be unanimous. Unanimous means that all 12 of them would have to agree together, one way or the other, guilty or not guilty, as to each individual charge. You understand that?
Yes, sir.
You understand by pleading guilty you're giving up your right to have a trial in this case?
Yes, sir.
Now, if we had a trial in any of these cases, the prosecutor here would be representing the state of Ohio, and she would have what we refer to as the burden of proof. With her having the burden of proof, what that actually means is that it is her job, or she bears the responsibility or the obligation to prove you guilty at a trial before you could ever be found guilty. You're presumed innocent of all these charges. The presumption of innocence sticks with you and remains with you until the state, if at all, was ever able at a trial to overcome that presumption of innocence and prove you guilty. You understand that?
Oh, yes, sir. My contact.
You all right? You need a Kleenex or something? Give him a tissue stand, please.
Contact expired. I'm all good.
You all right? Were you able to hear what I was just saying, or?
No, can you say it again,
Let me
please?
go over that one again. I noticed that your eye was bothering me. What I had said was that if we do have a trial, the prosecutor is going to represent the state in that trial.
Okay.
And she would have what we call the burden of proof. Having the burden of proof means that it's her job, her responsibility, and she bears the burden to prove you guilty before you can be found guilty. And what that means is you're presumed innocent of all the charges, and the presumption of innocence remains and stays with you until the state, if at all, was ever able at a trial to overcome the presumption of innocence and prove you guilty. Do you understand that?
Yes, sir.
Now, when I talk about this burden of proof, since these are criminal charges, that burden is what we refer to as proof beyond a reasonable doubt. It's the highest burden we have in our justice system. What it actually means, it's the amount of the evidence and the quality of that evidence the state has to present at a trial to prove you guilty. Right?
Yes, sir.
In each of these cases, the state would have to present evidence to prove each element or each part of the charges I just read to you beyond any reasonable doubt before you could ever be found guilty of any. Sorry?
No, sir.
I wasn't asking you a question. I was
Okay.
explaining to you. What I'm saying is that
Okay.
at a trial, the state would have to present evidence to prove each element or each part of each of these charges beyond any reasonable doubt before you could ever be found guilty. Do you understand that?
Yes, sir.
So do you understand by pleading guilty, you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt at a trial?
Yes. Yes.
Now, in order to try to do that, if we did have a trial in any of these cases, the state would be bringing witnesses into the courtroom to testify for the state by answering questions from the prosecutor. Once those witnesses answer the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same person's questions. That's called cross-examination. He could ask them, anything he wanted to within certain rules. Do you understand that?
Yes, sir.
Do you understand by pleading guilty, you're giving up your right to cross-examine or confront those witnesses that would come in here and testify against you?
Yes, I do, sir.
Now, you'd also have the right at a trial. You could call your own witnesses to come to court to testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that. You're not required to do that. But you have a right to do that if you want to. Do you understand that?
Yes, I do.
And you further can request this court issue an order. We call that order a subpoena. What a subpoena would actually do is it would force or make someone come to court and testify for you and answer your lawyer's questions if there was anyone out there that wasn't willing to come in voluntarily on their own. Do you understand that?
Yes.
Do you realize you're giving up that right?
Yes.
Now, you also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you have a constitutional right not to testify if you don't want to. That's a decision. That would be a choice that you would have to make. Do you understand that?
Yes.
And since that's solely your choice, what that really means then is that nobody else could force you or make you. Nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify. But most importantly, the prosecutor here, she's not allowed to call you as a witness and make you get up on the stand and answer questions and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes.
You further understand that if we went to trial and you were found guilty of any of these charges, you'd have the right to appeal or challenge that guilty finding to another court, a higher court that sits above me and reviews my decisions. By pleading guilty here today, you're giving up or waiving any right you have to appeal a guilty finding. This court will enter if your plea is accepted. Excuse me. Or any other issues you could have raised or brought to my attention up to this time. You understand that?
Yes, sir.
All right, well, do you have any questions at all about any of these rights we've just discussed? These are all the rights you have and all the rights you're giving up by pleading guilty. Any questions?
No, sir.
Do you understand them all?
Yes, sir.
You still want to plead guilty?
Yes, sir.
You understand a guilty plea is a complete admission of guilt. It means you're admitting to the facts being alleged by the prosecutor. We're not going to argue you didn't do it or it's someone else's fault or anything like that. Do you understand that?
Yes, sir.
Further, as a result of pleading guilty, the effect of that plea is you're going to be found guilty by the court, and then you will subsequently, on another day, be sentenced by the court. Do you understand that?
Yes, sir.
Now, as far as sentencing goes, you're pleading guilty to, well, let's start with 25-1450. You're pleading guilty to 2 charges. The grand theft of a motor vehicle is a felony of the 4th degree. That carries with it a possible term in prison of a minimum of 6 months, maximum of 18 months, or any whole number in that range of 6 to 18. Do you understand that?
Yes, sir.
Count 2 is the theft charge. That carries with it a possible term in prison of a minimum of 6 months, maximum of 12 months, or any whole number in that range of 6 to 12. You understand that?
Yes, sir.
Now, since there are 2 separate charges here, if I impose a prison term, I would impose a prison term on each count. Then as the judge, I have the discretion to run those prison terms either concurrent or consecutive. Concurrent means together at the same time. You serve the sentences at the same time. Consecutive is the opposite, one after the other. You serve the prison term on the first count, whatever it is, complete it, then serve the prison term on the next count. You understand the difference there?
Yes, sir.
So in this particular case, 25-1450, if I impose the maximum sentence on each count and ran them consecutive, you're looking at a maximum possible prison term of 30 months or 2.5 years in prison. You understand that?
Yes, sir.
Now in case 25-CR-1570, also 2 charges. The first count's the theft of a motor vehicle, a felony of 4th degree. Again, that's a 6 to 18 months in prison potentially. Count 2 is a felony of 5th degree. It's the misuse of credit cards, 6 to 12 months. Same thing with this case. I can run them if I impose a prison sentence concurrent or consecutive. If I give you the maximum sentence in each count consecutive, it would be 30 months in prison for this case. Do you understand that?
Yes, I do.
25-CR-1571. In each of the remaining cases, 1571, 72, and 73, it's 1 count. They're all grand theft of a motor vehicle. Each of these are punishable by a possible term in prison of a minimum of 6 months, a maximum of 18 months, or any whole number in that range of 6 to 18. You understand that?
Yes.
So the maximum prison term on each of these last 3 cases is 18 months in prison. You understand that?
Yes, sir.
Now, as I explained a moment ago, the 2 cases that had multiple charges, I could run the prison terms consecutive in each of those. At the time of sentencing, if I impose a prison term in each of these cases, I could run the prison term in each case concurrent or consecutive to each other as well. Do you understand that?
Yes, sir.
So I'm required to make sure you understand the maximum sentence you face here today by pleading guilty to all these charges. My math is correct. If I give you the maximum sentence on each of these cases and run them all consecutive, you're looking at 9.5 years in prison. You understand that?
You said 9.5? I think you said 4.
First 2 cases were 30 months each. That's 5 years.
So there's a 4
And the other 2 is
year, 4 and a
year and a half, year and a half, year and a half.
These are all 4s.
Okay.
So this is technically 4.5 for those 3, and then that's
It'd be 114 months.
2.5 and 2.5 here, so that's 5. Plus 4.5 is 9.5 technically. Not
For sure. I understand.
But in theory, that's what he's asking if you understand.
I understand.
That's if I gave you the maximum sentence and every count you pled guilty to and ran everything consecutive. The maximum sentence you face will be 9.5 years. Do you understand that?
Yes, sir.
Are you currently on probation or parole to any of the courts or agencies or any type of supervision?
Yes, sir. Cuyatta County
For what?
for the same thing. F4. I got an F4 theft.
Were you on probation when any of this happened?
Yes, sir.
I need to advise you that there may be consequences in that court. Is that the only court or anywhere else?
Oh, you said what?
Is that the only court or anywhere else?
Yes, sir. That's only court.
There may be consequences in that court with that judge for committing a new crime while on probation. If you commit a crime while on probation, it could be a probation violation. Nothing I can do about it or I'm going to do about it, but there could be consequences in that court there. Do you understand that?
Yes,
I need
sir.
to make sure you understand that.
Yes, I do.
Do you have any other charges pending against you anywhere?
Yes, I'm trying to think. Yeah, I do.
In Lake County or somewhere else?
No, I think somewhere else.
Sorry?
Cuyahoga County, and I think Summit.
Summit? Oh, yeah, Portage County. I have an M3 pending.
The only reason I bring that up, and I don't know if it'll be applicable here or not, but if you're not currently serving a prison term, are you?
No, I'm not.
If you get sentenced to prison in another court before you're sentenced here, and if I impose a prison term, I can run a concurrent or consecutive to that. But it already has to be imposed. If you're not going to leave here before that and go somewhere else, then that's probably not going to be an issue. If you've been sentenced to a prison term prior to being sentenced here, I can run a prison term concurrent or consecutive to that. But again, it has to be imposed. I can't run a prison term consecutive to some future possible unknown prison sentence. I can't say, if you get prison in Cuyahoga, then mine's consecutive. I can't do that. It's already got to be imposed. You understand that?
Yes, sir.
Right. Now, for each of these 5 cases, if a prison sentence is imposed in any of them, you could be placed upon your release from prison on what's called post-release control. It's sometimes called parole. It's a period of supervision you would be on after you completed the prison sentence. And for each of these cases, it could be up to 2 years. You understand that?
Yes, sir.
And if you are on post-release control for any of these cases and you never violated any of the rules of your supervision, the parole authority could send you back to prison as punishment for violating the rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of whatever the prison term was imposed by the court. Do you understand that?
Excuse me, say what?
I'll say that again. If you are on post-release control and you violate any of their rules of supervision, the parole authority can send you back to prison as punishment for violating their rules. And it could be up to 9 months in prison for each violation you commit, up to an overall maximum of 50% or half of whatever the prison term I impose is.
Okay, I understand.
Okay. Now, aside from the possible prison sentence I just explained, there's other sanctions that could be ordered. You could be fined in each of these cases. In 25 CR 1450, the grand theft of a motor vehicle carries with it a possible fine of up to $5,000. The theft of the credit card involves, a possible fine of $2,500. So altogether, in this case, $7,500 possible fine. No fines are mandatory. You understand that?
I understand, sir.
In the other case, 1570, that is the 2 counts also. The grand theft of a motor vehicle is punishable by a possible $5,000 fine. Misuse of a credit card is $2,500. Again, maximum fine in that case is $7,500. Do you understand that?
Yes, sir.
In the remaining 3 counts, they each have 1 count of grand theft of a motor vehicle. Each of those are punishable with a possible fine of $5,000 each. Do you understand that?
Yes.
So altogether, with each of the 5 cases, a possible maximum fine of $30,000. Do you understand that?
Yes, sir.
You could also be ordered to pay court costs or reimburse the county for any cost of confinement, community supervision, or treatment if any of that were applicable in any of these cases. Do you understand that?
I understand.
Also, you could be ordered to pay restitution to any victim for any economic loss any victim may have suffered as a result of the criminal conduct involved. Do you understand that?
Yes, I understand.
Now, a few moments ago, I explained the possible prison sentence you face. I used the word possible in doing so because prison is not mandatory or required for any of these cases or charges. You are eligible in each case for probation or what's called community control sanctions. Do you understand that?
Yes, sir.
Do you understand that just because you're eligible doesn't mean you'll automatically get probation? It means I'll consider that if that's what you're asking for. I'm going to look at all the information presented. Then I'll make the decision I think is the right thing to do. You understand that?
Yes, I understand, sir.
Now, if you are put on probation, it could be for up to 5 years of supervision. And as the judge, I do have the discretion to order a wide variety of rules or conditions for you to follow. One of the conditions of probation can be in order that you serve a term in the Lake County Jail of up to 6 months, the condition of probation. You understand that?
Yes, sir.
Further, if you are ever on probation to this court, you violate any of the conditions of your supervision, we would have a hearing here in court to see if you're what's called a probation violator. And if it was determined that you were, I could extend your probation up to 5 years if it wasn't originally 5 years. I could impose more restrictive sanctions against you, or I could terminate or end your probation and send you to prison at that point. And if I did it then, again, it could be for the period of time in each case that I mentioned earlier, up to a maximum with all 5 cases of 9.5 years in prison. You understand that?
Yes, sir.
That could also be ordered to be served consecutive to any other prison sentence you may be serving at that time for any other case, or that you're being sentenced to if there's any new cases. You understand that?
Yes, I understand, sir.
Lastly, when we do come back here for sentencing, you're going to have the right at that time to say anything you want. Anything you want me to know or consider. Your lawyer could speak on your behalf. He can recommend the sentence to the court. The prosecutor here can also recommend the sentence to the court. Do you understand that?
Yes, sir.
Do you understand that whatever anyone says at sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation. I don't have to go along and follow that if I didn't think that's the right thing to do. You understand that?
Yes, I understand, sir.
All right. Well, are there any questions for me about the potential penalties you face by pleading guilty?
No, sir.
You understand all the possible consequences?
Yes, I do.
You still want to plead guilty to these 5 cases?
Yes, sir.
Have you had enough time to talk about these cases with your lawyer and have him review everything with you, answer all your questions?
Excuse me?
Have you had enough time to go over everything with your lawyer, meet with him, talk with him, have him review everything with you, answer
Yes,
your
sir.
questions? Are you satisfied with his advice and counsel?
I am.
Has he, or has anyone for that matter, made any promises to you about what's going to happen at sentencing which is inducing you to plead guilty?
No, sir.
Have you been threatened or coerced by anyone to plead guilty?
No, sir.
Are you entering your guilty plea freely and voluntarily?
Yes, I am, sir.
All right then, Mr. Hudson, any questions for me at this time regarding anything we just talked about? What you're pleading guilty to in each case, the rights you're giving up, the penalties you face, any questions?
No, sir.
Do you need any more time to talk to your lawyer before we go forward with your guilty pleas?
No, sir.
All right, then what we're going to do at this time, the prosecutor is going to present me with the facts that she believes would be demonstrated at a trial if we had a trial. We'll do one case at a time. I want you to listen to what she says because then I'll have some follow-up questions for you, all right?
I understand.
So I'll leave it up to you to just say what case you're talking about first, and then we'll do one at a time.
Starting with 25 CR 001450.
All right, this is the chart case with one count of theft of a car and one count of theft of a credit card, Mr. Hudson. Go ahead.
That's true. Had this matter proceeded to trial, the state would have proven beyond a reasonable doubt that on September 29th of 2025, initially just before 4 p.m., Willoughby Police Department responded to the Heinens located on Ridge Road in Willoughby, Lake County, Ohio for a theft report. Anthony Tortorici indicated that he works at Heinens, had left his wallet in his vehicle. When he came out later, he found that his car door was open, his wallet was gone. He had also received a notification that his debit card had been used at a Walgreens for a purchase just under $40. Officers went to Walgreens, found out that a Visa gift card had been purchased. They were able to view the video to see the individual who was involved. Shortly after that, same day, approximately 4:45 p.m., Willoughby Police Department responded to the area behind the Night and Day Club on Euclid Avenue in Willoughby, Lake County, Ohio, for a theft of a motor vehicle. Robin Bostic indicated that her 2019 Chevrolet Impala had been stolen between approximately 4 and 4:40 p.m. She had parked it in that area. She had left her purse in the car, which did contain her keys. The car was gone when she came out. Through flock and video of businesses in the area, the individual who had taken the car was able to be seen in those videos. It was determined that both the credit card theft and the auto theft were the same defendant, who was later identified to be Sean Hudson, the defendant. On October 2nd of 2025, the Chevy Impala was recovered in Garfield Heights, where the driver and sole occupant of the vehicle was in fact the defendant, Sean Hudson. He also had in his possession Robin Bostic's credit cards as well as gift cards. When officers spoke with Mr. Hudson, he agreed he got the card from Willoughby and that he had bought a gift card at the Walgreens. All this occurring in Lake County, within the state's evidence in that case.
Mr. Hudson, were you able to hear what the prosecutor just had to say regarding what she believes the evidence would show at a trial in case 25 CR 1450 if we did have a trial?
Yes.
What, if anything, do you have to say about those facts as she presented them? Are they true? Did you do what she said?
Yes, I did, sir.
Very well then, regarding count 1, charging you with grand theft of a motor vehicle, felony to the 4th degree, what is your plea to that count?
Guilty.
Regarding theft, felony to the 5th degree, this is count 2, what is your plea to that count?
Guilty.
All right, Ms. Putz, please move on to the next case.
In 25 CR 001570, had that matter proceeded to trial, the state would have proven beyond a reasonable doubt that on October 1st of 2025, around 11:20 a.m., the Mentor Police Department was dispatched to a dental office on Mentor Avenue in Mentor, County, Ohio, for theft of a motor vehicle. They spoke with Ashley Carney, who indicated that she had arrived at work that morning in her black 2024 Ram 1500. She had parked it and rushed in, leaving her purse with her car keys in the vehicle. She received a text notification that her American Express card had been used at a Target in Willoughby in Lake County, Ohio. When she went to check on her card, she saw that the truck was gone. In addition to the American Express card, there was also a Discover card and 2 different Visa cards. She was able to track the location of her vehicle to Glenville Avenue in Cleveland. The car was recovered in that location by the Cleveland Police Department. Ms. Carney learned that her 3 credit cards had been used at the Willoughby Target as well as the Euclid Marks and Euclid Walgreens, totaling almost $1,300 worth of items that she did not purchase and not give permission to purchase. Willoughby Police Department followed up with Target getting the video, seeing the defendant, Sean Hudson, using the credit cards. When Willoughby was interviewing the defendant, he did admit to taking the Ram truck. You saw a picture of it identified as one he had taken, as well as the credit cards were in the car. All this occurring in Lake County, Ohio, and that would have been evidence in 1570.
Thank you. Mr. Hudson, were you able to hear what the prosecutor just had to say as to what she believes the evidence would establish in this case if we had a trial?
Yes, sir.
What, if anything, you have to say about these facts? Are they true? Did you do what she said?
Yes, I did, sir.
Very well. Regarding count 1, charging with grand theft of a motor vehicle, a felony to the 4th degree, what is your plea to that?
I plead guilty.
And regarding count 2, charging you with misuse of a credit card as a felony to the 5th degree, what is your plea to that?
Guilty.
All right. Ms.
20
Cutts, next case.
In 25 CR 001571, this matter proceeded to trial. The state was proven beyond a reasonable doubt that on September 21st of 2025, around 2:45 p.m., Willoughby Hills Police Department was dispatched to the lobby of 2260 Carr Lane, which is the Pine Ridge Apartments in Willoughby Hills, Lake County, Ohio, for a stolen vehicle report. They spoke with the Devon Boyd, who indicated that his 2017 black Dodge Ram Rebel had been parked in the parking lot. He had left it the day before. When he had come out that afternoon, the vehicle was gone. Looking at block video, they were able to see the vehicle was taken approximately 4:54 p.m. on September 20th of 2025. On September 27th of 2025, Cleveland Police Department recovered the vehicle. Willoughby Hills Police Department detective went and spoke with Mr. Husband, who indicated that he had in fact taken the vehicle from Pine Ridge Apartments. He had initially told Willoughby Police Department, who notified Willoughby Hills, who spoke with the defendant, Mr. Hudson, directly. He admitted to taking the vehicle, and that is all occurring in Lake County, Ohio, and that would be the evidence in 1571.
Mr. Hudson, were you able to hear what the prosecutor had to say regarding what she believes the evidence would establish in this case if we had a trial?
Oh, yes, sir.
What, if anything, you had to say about these facts as you presented them? Are they true? Did you do what she said?
Yes, I did, sir.
Very well. Then regarding case 25 CR, it's 1571, correct?
Correct.
1571. Charging you with grand theft of a motor vehicle, a felony of the 4th degree. What is your plea to that count?
Guilty.
All right, Ms. Cutts, the next case, please.
In 25 CR 001572, had this matter proceeded to trial, the state was proven beyond reasonable doubt that on August 2nd of 2025, around 9:50 a.m., Wycliffe Police Department officers responded to the Center for Pastoral Leadership on Euclid Avenue in Wycliffe, Lake County, Ohio, for report of a stolen vehicle. They spoke with Joseph Costello, who indicated that his white Subaru Ascent was missing from the parking lot where he had parked it. Again, flock was reviewed to see whereabouts, as well as it was determined how to activate a tracking location system for the vehicle. It was found to be at 15620 Damon Avenue in Cleveland, Cuyahoga County. Officers went to that location, located the vehicle there. Swabs were taken. There was a charger in the vehicle that was not the owner's, that was also swabbed. That came back to defendant Sean Hudson. On October 10th, 2025, Wycliffe Police Department detectives went and spoke with the defendant, who did admit, Sean Hudson, the defendant, did admit to stealing the Subaru, that he had parked it, and then later saw that the police were at it. He admitted the charging cord in the vehicle was in fact his. All this occurring in Lake County, and that was in the state's evidence in 1572.
Mr. Hudson, were you able to hear what the prosecutor had to say regarding what she believes the evidence would establish in this case if we had a trial?
Yes, sir.
What, if anything, you had to say about these facts as she presented them? Are these facts true? Did you do what she said?
Yes, sir, I did.
Very well. Then regarding count 1 in case 25 CR 1572, charging with grand theft of a motor vehicle, felony of the 4th degree. What is your plea to that
I
count?
plead guilty.
All right, last case, please, Ms. Cutts.
Thank you, Your Honor. In 25 CR 001573, had that matter gone to trial, the state would have proven beyond a reasonable doubt that on August 31st of 2025, shortly after 10 p.m., Eastlake Police Department officers responded to Arlo Precision at 1630 East 361st Street in Eastlake, Lake County, Ohio, for a report of a stolen vehicle. William Dolan indicated that he arrived at the location that evening at approximately 8 p.m. When he left around 10 p.m., was going to leave, his vehicle was gone. It's a red 2016 GMC Canyon truck. On September 1st of 2025, the vehicle was recovered in Akron. Inside the vehicle was a white phone charger that was not Mr. Dolan's. Swabs were taken of the vehicle and the charger. It came back to the defendant, Sean Hudson. When officers spoke with the defendant, specifically Willoughby Police Department, he did admit to taking the red GMC truck down the street from Target. All this occurring in Lake County, Ohio, and within the state's evidence.
Mr. Hudson, could you hear just now what the prosecutor had to say? The facts would be in this case if we had a trial?
Yes, sir.
What, if anything, you have to say about these facts? Are they true? Did you do what you said?
Yes, I did, sir.
Regarding count 1, then, charging you with grand theft of a motor vehicle, felony of the 4th degree, it's case 25 CR 1573. What is your plea to that count?
Guilty.
All right, in each of these cases, I have 5 separate documents called a written plea of guilty and judgment entry. Each of these documents set forth what I've just spent the time going over with you and reviewing with you, the rights you're giving up, the penalties you face, what you're actually pleading guilty to. Before I can accept your plea in any of these cases, I need to make sure you understand what these documents say and that you've signed them here in court. Now, they're all identical, again, except for the individual charges that go along with each particular case. Otherwise, they all say the same thing. And the penalties could be different for each case. Obviously, we've already gone over that. My understanding is before I walked out here, you had a chance to review each of these documents with Mr. Watson. Is that correct?
Yes, sir.
Mr. Watson, is that correct? Did you review these documents with your client? Read them to him, answer his questions?
Yes, Your Honor. So I did review each individual written plea of guilty form with my client. I read through it. He read along with me. He indicated he understood it. He signed them, and I signed them in the presence of the prosecutor, Your Honor.
Is that correct, Mr.
Yes, sir.
Hudson?
Yes, sir.
So you understand what these documents say?
Yes, sir.
Do you have any questions for me about any of them?
No, I do not, sir.
Now, your lawyer indicated, and it appears from looking at it, that you signed each of these documents. Did you in fact sign them all?
Yes, sir.
Ms. Cutts, you witnessed that too?
I did, Your Honor.
Very well, then. At this time, the court will accept the defendant's oral and written pleas of guilty. Let the record reflect. The defendant was here in open court with his lawyer, advised of all his constitutional rights, and made a knowing, intelligent, and voluntary waiver of those rights in each of these cases. The court also finds the defendant understands the nature of each of the charges, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding all of this to be knowing, intelligent, and voluntary, the court will accept the defendant's pleas of guilty in each case. And in case 25 CR 1450, I'll find the defendant guilty of count 1, grand theft of a motor vehicle, felony of 4th degree in violation of 2913.02A1, and count 2, theft of felony of the 5th degree in violation of 2913.02A1. In case 25 CR 1570, I'll accept the defendant's plea, find him guilty of count 1, grand theft of a motor vehicle, a felony of 4th degree, violation of 2913.02A1, as well as count 2, misuse of a credit card, a felony of the 5th degree, in violation of 2913.21B2. In cases 25 CR 1571, 1572, and 1573, I will also accept the defendant's guilty pleas. In each of those cases, I'll find him guilty of count 1 in each case. Each count is grand theft of a motor vehicle. They're each felonies of the 4th degree, and they're each in violation of 2913.02A1. In case 25 CR 1470, I'm going to continue to defendant's bond of $50,000 cash surety. In the remaining counts or cases, I'm going to set bond in each of those cases at $5,000 cash surety. I'm going to order a pre-sentence report and investigation in each of the 5 cases, a victim impact statement in each of the 5 cases. Is there anything else you're requesting, Mr. Watson?
Your Honor, I believe it was brought up by the state, but if I believe a psychological evaluation might be appropriate, Your Honor.
And we'll do a psychological evaluation in each case as well. So, Mr. Hudson, I've referred you to the probation department so they can prepare some reports. The way they prepare the reports is they need to conduct some interviews with you beforehand. They'll bring you over, or they'll send you information, or come over and see you. I'm not exactly sure how they'll do it, but you'll be getting information or meet with them. It's important that when you meet with them and speak with them and fill out paperwork that you're open and honest with them, because they check and verify everything you tell them. And if they learn you're misleading them in any way, if you're not cooperative with them, they're going to let me know that, and I would obviously consider that as sentencing. You understand that?
Yes, sir.
All right, in each of the in four cases, 1570 through 73, I've also signed an order that the defendant get booked into the jail on each of these cases, so we'll send that order over to the jail so they can deal with that. I think that covers everything. Ms. Cutts, is there anything else?
No, thank you, Your Honor.
Mr. Watson?
Nothing further, Your
All
Honor.
right, thank you.
Okay, this now. This is Yohan Lopez, page 4. Yohan Lopez, private attorney. Can you raise your hand? Who is it? Thank you. I got 2 lawyers. Oh, and the bondsman. You got a bondsman here. Thank you for the bondsman raising your hand.
Spanish interpreter, please.
Spanish. Good morning, sir. You were arrested for burglary to an unoccupied conveyance. I'm sorry, burglary to an unoccupied dwelling, dealing in stolen property, grand theft, a 2nd-degree felony, and unlawful use of a communications device.
Good morning, Your Honor.
Buenos días, usted enfrenta varios cargos, solo uno tiene que ver con hurto mayor, tiene que ver con ingreso ilícito a una vivienda desocupada y también por tenencia ilícita de un dispositivo de comunicaciones
And also criminal mischief.
y también por daño en propiedad, fechoría.
Your attorney is present. Can you state your name for the record, please?
Attorney Arturo Taquechel on his behalf, Your Honor. Good morning.
Se acaba de presentar el abogado que lo está representando.
Good morning. I also have in court, are you police officers?
Yes, detectives.
Detective, please raise your right hand to be sworn. Do you swear or affirm, there's two detectives. Do you swear or affirm the testimony you are going to give in this proceeding will be the truth? If so, state I do.
Está también presente el oficial que acaba de presentar juramento.
All right, detectives, I guess I'll start with you. What is your name, please?
Detective Jonathan Gross.
Okay. And who are you?
Detective Juan Segovia. I'm the sheriff.
Thank you.
Se acaban de presentar dos detectives que están ahí presentes en el juzgado.
All right, so let me give me a moment to review this arrest affidavit for probable cause. So this is an incident that goes back to September 12th of 2025.
Este incidente se remonta al 12 de septiembre del 2025.
Okay, I had a chance to review the arrest affidavit. Detective Grossman, what do you want to tell us?
Acabo de leer el informe del arresto, dice la juez, y le pregunta al detective qué quisiera el detective decir.
We're just here in the event the state needed anything.
Estamos acá solamente en caso de que la fiscalía necesite algo.
What were the damages to the amount of damages to the victim's apartment? There's no amount of damage to it.
My understanding.
La juez pregunta a la fiscalía cuál es la cantidad de daños que sufrió el apartamento de la víctima.
It was a door lock. I believe they estimated it on the chart between 200 and less than 1,000.
Okay.
Sir Fletcher, pero what was that again, please?
That it was estimated between 200 but less than 1,000. I think it's what.
Fue entre 2,000, entre 200 y 2,000.
There was no value listed in the body, the sworn narrative.
I'm sorry. That's my understanding.
Okay. All right, so you don't. All right, any questions for the detectives?
No questions, just argument, Judge, whenever the court's ready.
La fiscal no tiene preguntas, solamente un argumento.
And Mr. Takashel, did you have any questions for the two
I do.
deputies?
I do not, Your Honor.
El abogado tampoco tiene preguntas para el detective.
All right, so,
Judge,
sir, 1 second, sir, you are ordered to stay away from the victims. You want what's the victim's initials? State.
victim's initials are ADH.
Stay away from the alleged victim whose initials are ADH.
Tiene que mantenerse alejado, le ordena la juez, de la víctima cuyas iniciales son ADH.
No contact with the victim either directly, indirectly, in person, in writing, by telephone, or through third parties.
Puede contactar a esta víctima ni directa ni indirectamente, tampoco en persona, ni por teléfono, ni a través de terceros, ni por escrito.
No contact with the victim through social media or other electronic means.
No podrá contactar a la víctima a través de las redes sociales ni por ningún otro medio electrónico.
And you must stay at least 500 feet away from the victim the victim's home, school, and place of employment at all times.
Y en todo momento se tendrá que mantener alejado por lo menos a 500 pies de donde la víctima vive, trabaja o estudia.
And you must stay away from his victim's residence at 1032 Northwest 87th Avenue in Miami, Florida.
Y en todo momento tendrá que mantenerse alejado de la casa de la víctima, que queda en el 1037 de la 82 de la Georgia 87th Avenue, right?
87th Avenue, yes.
Thank you, Honor. De la avenida 87 de Miami, Florida.
Okay. Do you understand the stay away order?
Señor, ¿usted entiende la orden de alejamiento?
All right. I had one
Judge, the
question.
state's requesting an increased bond on this case. It looks like they cased the residence and burglarized the house, a house that had appears to be, very expensive jewelry.
Really? I don't see a
I
value
don't know
for
if
jewelry.
it talks about diamond. It talks about diamond jewelry and a
Where does
Rolex.
it say the value of the jewelry on here? I don't see it.
So
It
detectives.
says Rolex watches. I don't know. How do I know it's real? Is it Detective Segovia?
Yes, Your
What's the
Honor.
value of the jewelry that was the victim?
Your Honor, I do not know. We were assisting the Midwest District. What I wanted to tell you was that this is a very well organized and sophisticated group of burglars that have been terrorizing the area. The last time this group was taken down, about approximately 2 years ago, the percentage of burglaries that went down in Midwest District for Miami-Dade Sheriff's Office was 68% just from taking this group down. 2 years later.
Estos detectives, señoría, primero que todo, la fiscal está pidiendo una fianza elevada debido a la cantidad sustancial de joyas y relojes que sustrajeron de la vivienda. El detective dice, señoría, este individuo pertenece a una banda organizada que por los últimos 2 años ha venido aterrorizando el sector con...
Well, can you call up Officer Matthew who wrote and find out the value? We'll pass the case for a minute. We need to find out the value of the merchandise that was taken.
Para pasar el caso porque la jueza está pidiendo que se dé un desglose de la cantidad del avalúo de las joyas.
Have a seat. We'll be with you in a moment.
Thank you, Judge.
Tome asiento, van a volver a llamar su caso.
Detectives are going to call.
What?
I wanted to see if I needed to call or if the detectives are going to call.
You what?
I wanted to
You're
see if
following up the detective who wrote this.
Excellent. Thank you, Judge.
All right, next we have Menachem Paris, page 5, private attorney. So here we go. Mr. Takashel, I'm putting you as an attendee since you're not putting off your camera. When you come here and I'm not on your case, you need to turn off your camera. But since you're not doing it,
Your Honor wants me to turn it off?
Until
yeah,
the case is recalled.
you need to know Zoom etiquette here. Turn off your camera until your case is.
Your Honor, that's for Paris, correct? I don't have that person as a.
Paris isn't here yet.
Oh,
Hi, Mr.
Malcolm
Mason.
Abraham on behalf of Paris, so I'll wait.
He's not here yet. Can you get him so we can? The one from yesterday.
The third
They
roommate
had
looks
three
like.
boys living in this house doing this. That's terrible.
Yes, Your Honor.
I'll pass the case. Out of church for correction. Sorry. Next we have Gian Crespo, page 20. Also, there's family here for some cases. I'll try and get those. Did you get the value yet?
Yes.
When you're ready, I'm recalling Johan Lopez. They got the value. So bring in whoever you got. I'm out of control today with the organization. Let's be happy it's Friday. I got to pass your case. Oh, he's here now. All right, Mr. Mayberger, client's here.
Good morning, Your
Yes,
Honor.
Mr. Harris, good morning. You were arrested for trafficking in amphetamines, trafficking. This is Mr. Crespo. Oh, it's Mr. Crespo. I'm sorry.
62 on the calendar on page 20.
Pardon me. Oh, no. Mr. Crespo, you were arrested for escape, tampering with an electronic monitoring device, in criminal mischief. I will appoint the public defender's office for you. So, count one, the escape. What do you want? An ROR or $1?
$1.
Count one is $1. Count two is $2,000. Count three is $500. Have a nice day.
Welcome again, everybody. Happy Super Friday. It is the Courtroom Files. We are live. We are watching Judge Glazer kind of walked the line on a possible Friday meltdown already. We'll see how it goes. We'll stick with her for a few more minutes as other courts come online.
With Spanish interpreter. So, sir, we're back. The detectives or deputies walk back in the courtroom. Detective Grossman, hello, good morning.
Yes.
Ya, señor, su caso lo están llamando de regreso. Aquí están los detectives presentes en la sala de juicio.
After conferring with the primary lead on the burglary case, it's estimated that the value of the items that were stolen was $30,000.
Se estima que el avalúo, la cuantía de los artículos robados asciende a los $30,000.
Okay, thank you.
That would make it a grand theft second.
What?
That would make it a grand theft second.
All right, Mr. Takashel, do you have any argument regarding your client and the bond this court should set?
No, Judge, I'd just like to request a standard bond be set and posted by him. He's not a risk of flight nor a danger to the community.
La juez le pregunta al abogado si tiene algún argumento. Él dice que no, él está pidiendo simplemente la fianza estándar. El abogado alega que su representado no representa riesgo de fuga y no representa riesgo para la comunidad.
He had numerous arrests back in 2013 for burglaries and grand theft and criminal mischief, and it looks like he got 3 years in prison.
That's correct, Your Honor.
Bueno, desde el 2013, este acusado ya fue arrestado varias veces por ingresos ilícitos a viviendas y también por hurto mayor. El abogado confirma esa información.
And then there's, he just got off of probation earlier this year. It looks like grand theft of a vehicle, resisting without, and offenses against computer users.
De hecho, ya había terminado libertad probatoria a comienzos de este año por hurto mayor de un vehículo y también por resistirse sin violencia.
Corrections, does he have any immigration holds or no?
No, he does not.
No, Judge.
No tiene orden de retención migratoria.
All right.
So the state's requesting a $50,000 bond on the burglary based upon these facts, as well as the defendant's criminal history.
Entonces, a la luz de estos hechos y del historial criminal de este acusado, la fiscalía está pidiendo una fianza de $50,000 por el delito de ingreso ilícito.
Also requesting Nebia and house arrest.
Y también una audiencia tipo Nebia y arresto domiciliario.
It's overkill, Your Honor. Once again, I request Your Honor set a standard bond, and that would be sufficient to guarantee his presence in court.
El abogado dice que no amerita tal cantidad, que la fianza estándar es suficiente y que para que garantice que regrese a comparecer por estos cargos.
He's a signal 100. I'm setting a bond count 1 burglary to the unoccupied dwelling is $50,000 bond. Count 2 dealing in stolen property will be $2,500. Count 3 grand theft. I'm splitting 2 and 3. You can't be convicted of both. $5,000.
Entonces, por el primer cargo, por ingreso ilícito, $50,000 de fianza. Por el segundo, por comercializar con mercancía robada, $2,500. Por el tercero y el cuarto, $5,000.
Count 4 unlawful use of a communications device is a 3rd-degree felony. That's $2,500. And count 5 criminal mischief, no value, $150.
Por el cuarto son $2,500 y por el quinto, Your Honor, for the interpreter for the fifth one, how much is it again, please?
$150 for count 5.
Got it. Thank you, Judge. Y $150 por el número 5.
Also, it's house arrest with a GPS monitor, level 3 house arrest.
La juez le impone también arresto domiciliario nivel 3.
And no curfew and a Nebia requirement. You have to show the money used to post your bond is from a legitimate source of funds.
Se le impone también un requisito Navia para demostrar que los fondos que va a usar para pagar esta fianza vienen de un fondo legítimo.
Was you going to do the curfew? It looks like he.
No, I didn't do a curfew. He's doing this during the day.
Curfew.
He's not, Judge.
He's not? Is it doing a curfew or
So
no?
the victims said at 9:30 in the morning. Oh, hold on. Okay, you're right. He did.
It's a curfew, Judge. He's a grown man.
Well, that's to make sure there's no crime
I mean,
out and about. But
we've already raised the standard bond. We've already put an ankle bracelet on him. We've,
I didn't give him a curfew. I let him listen. He didn't have a monitor. That place where he sold it, did they sell the jewelry or they own that jewelry store in the Seabold?
So he would the items were stolen and then he would go to the Seabold building and offload the.
Oh, okay. Have a nice day. Thank you, Mr. Takesh. You have a good lawyer.
Okay, that's a total of $60,000. The bond. 150.
Right. Okay, thank you.
And it's a level 3 house arrest.
Level
correct?
3, it's just going to wear a monitor. We're going to know where he is.
Right, but it's rolling. Very good. Thank you.
También le pondrán un grillete electrónico para saber dónde está.
Matter of the state of Michigan versus Crystal Zamorsky, 251612, and the state of Michigan versus Crystal Zamorsky, 251614.
Good morning, Your Honor.
Okay, go ahead, counsel.
Do we have to do a reading first from the officer?
Well, yeah, so I thought you were trying to put your appearance on the record. Okay, just good morning. All right, and so detective, your name for the record, please. Oops, you're still muted.
Your Honor.
Okay, very good, thank you. All right, your name for the record, please.
Detective Joseph Carwine, Police Department.
All right, please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, thank you. And you may proceed on the warrant.
Your Honor, on November 15th, 2025, Officer Carpo was reported that she was dispatched to 1110 Sycamore Street regarding a larceny complaint. Officer Carpo reported that she arrived at the address and spoke with the victim, identified as a Dana Jakubiak. Officer Carpo reported that the victim stated that on 11:13, she noticed the gate located in the west side of her home to be unlocked and open, which was unusual. Officer Carpo reported that she checked her home security video and discovered that on 11:13, about 12:30 p.m., an unknown white female, later identified as the defendant, Crystal Zamorsky, is seen unlocking the gate and entering the yard and subsequently stealing items from a parked, unlocked travel trailer, which was located in the backyard. Officer Carpo reported that the victim showed her several home security videos where she observed and immediately identified the white female as the defendant from several prior police contacts. Officer Carpo reported the defendant is seen arriving at 1110 Sycamore with no shoes on and what appears to be a shorts or no pants. And a short time later is seen leaving via the same gate, wearing black boots and carrying a black bag, which was identified belonging to the victim. Officer Carpo reported she reviewed additional home video from the address, which showed the defendant running in front of the home, wearing the black boots and carrying the bag. Officer Carpo reported that the victim had checked the backyard and camper area and discovered items stolen from the camper and damage to the garage. And, the items stolen include a pair of black hunter boots, a Nintendo gaming console, Amazon Fire Stick, and this gate locking mechanism. Officer Carpo reported that she checked the defendant's status in Lean SOS and discovered that she had an outstanding warrant on the 27th District Court for a weapons offense. Officer Carpo and Kyle Cox arrived at the defendant's address located at 974 Eureka Road and made contact with her, where she was subsequently arrested on the local warrant and on the larceny. I spoke with the victim in the case the next day, and the reported items stolen appeared to be over $1,000, but less than less than 20,000, and the damaged property appears to be over $1,000 and less than $20,000. And Your Honor, may I note that the defendant is also a second offense notice, which indicates that on October 10th, 2019, she was convicted of a felonious assault in the Third Circuit Court in Wayne County.
All right, thank you. Upon examination of the complaining witness, I find the offense charges were committed and that there's probable cause to believe the defendant committed those offenses. Counsel, your appearance, please.
Good morning, Your Honor. Christopher Shemp, appearing on behalf of my clients. Time and consent to the matter being heard via Zoom.
Thank you. Ms. Zamorsky, your name for the record, please. Okay. And counsel, you're on the felony matter as well as on the assault and battery matter from November 13th As to the arraignment on those matters, what are you requesting?
We waive formal reading. My client stands mute.
All right, the court will waive the formal reading. As to 251612, the court will enter plea of not guilty, schedule this matter for pretrial on November 25th,
1:45.
1:45 p.m. And ma'am, you do have, as to the felony, you do have the right to have an attorney. If you cannot afford one, you may have one appointed to represent you. In fact, you've had the opportunity to speak to an attorney today, correct?
Yes.
All right, the court's also signed the petition order for appointing an attorney for felony matters as well. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have a trial by a judge or by a jury. You also have the right to remain silent. Anything you say orally or in writing may be used against you in court. Do you understand those rights?
Yes.
All right, the court's entering a plea of not guilty on your behalf on the felony matter, scheduling this matter for probable cause conference November 25th at 1:45. And as to bond counsel.
Your Honor, my client was gainfully employed. This arrest might jeopardize that. But that being said, she indicates she will come to any and all future court dates. She will comply with all provisions. I know financially she would have a difficult time coming up with a monetary amount, so we would ask consideration for any leniency this court could consider when determining an appropriate bond. Thank you, Your Honor.
Okay, so ma'am, you're currently on probation, right? Out of the Third Circuit Court because you failed to complete probation. There's a warrant for your arrest. Is that the issue?
What is that? I'm not on probation at no Third Circuit Court.
No?
No, ma'am.
Are you on probation in this court?
No, I did drug testing for you and I passed every drug test that you asked me to do. And on my jail review, I talked to the probation lady. I was currently in the hospital and I emailed you guys the paperwork. I called and I didn't get no return phone call regarding that. And I still have the paperwork. If you need that, I can get that.
What's the, okay, hold on. Detective, what's the warrant that is pending for Ms. Zamorsky?
Your Honor, that is out of our 27th District Court. It looks like a weapons offense.
For jail review. And I was in hospital that day.
Okay, hold on, ma'am, hold on. Can you pull that one out, please? That must be the one from April.
It's dated, issued on the 21st of October of 2025, Your Honor, so.
Okay. Do you have that file?
I didn't hear. I was walking over here. She's on jail review.
I know. Right, I need the file. Can we get the file since she's already in custody?
And there's her note.
Is the fact statement on April 5th?
Yes.
Yeah, it's in yours. She fills up here for the jail review October 20th.
I talked to Natalie Shaw and I let her know that I was gonna be in the hospital.
No, ma'am, you emailed October 24th and you didn't submit any paperwork. And as far as the email goes that you're addressing, and so then you were notified you needed to either post bond, and if you post a bond, we'd recall the warrant, or you could walk in. You didn't do that.
I did email. I don't know if it didn't go through or not, but I guess I did do that.
You're not listening to what I said. You're not listening to what I said. Yes, you emailed October 23rd. And then I reviewed the email. You didn't attach any proof of being in the hospital. In fact, all you said on here was that you were sick. In fact, I'll read the email, ma'am. Yes, my name is Crystal Zamorsky. I had court the 20th. I have been very sick. I have told Marcy. She demanded the paperwork next day and told me, I don't know, or IDK, if you can reschedule my court date. I have to ask, she said, and that's wrong by law. You have to. I'm still very sick. And also some very, very serious things happened taking care of regarding my job with 2 or more employees. that did identity fraud and had taken all my money. It's in the process of being handled. Also, the court needs to know my mother, Chris, calling police saying I hit her. That's a false report, but I had the police called that day to tell them everything going on. And I have got justice from not one officer. I'm tired of everyone lying and calling in on me with the most ridiculous things. Even I do biting, but sit at home until my mother kicked me out. Now I'm homeless. I want to know why I get cops coming to my house every single time a person calls or makes a lie up, any type of thing about me, period. They're at my door ready to put me in cough, period. Just like when I was, the rest of my mom lied and said I hit her. That's the other sentence, period. I was sleeping when I was arrested, period. There's no proof, nothing, period. I don't understand how that's fair, period. I'm being harassed by a little by police and I want to have it stop, period. This is ridiculous and I'm tired of it. I'm to the point where I don't even want to be here anymore. I'm tired of everyone, family, the city accusing and treating me terrible. It's not fair. I want to have a call from the main person. I'm able to speak to the judge personally. That'd be great. Can you guys please get a hold of me? Because last time I got there, nothing was ever mailed to me and no one ever returned my phone call. Please and thank you, period. Have a good day. That is the email that you sent in October 23rd. The response to that, ma'am, was that you either needed to post a bond, and if you did post a bond, then we would recall the warrant, or you could walk in.
I apologize. I didn't get it.
Ma'am?
Check my email.
Stop. You sent an email. You should check your email. And you didn't do that. So don't try telling the court now that you were trying to come into court. So, because you just said that you were in the hospital. Didn't you say you were in the hospital? That's why you missed court?
Yes, I was.
Okay, not anywhere in this email does it say you're in the hospital. Your credibility is about nothing with this court, ma'am. You see that right there. Okay. And so, counsel, as to bond.
Your Honor, just any leniency this court consider. I believe that my client obviously realizes that there are consequences. She's not appearing in court. She's experiencing them. So we just ask for anything which would potentially allow her to get out of custody, or at least a 10% cash surety provision.
I do have a job that I'm supposed to be checking up on that. It's at a dental office. I can't check it then at home at my phone. You know, I lost a lot. My car got totaled September, a day before my birthday, and my whole bank account got frauded. I'm trying. It's just, I don't know, ma'am.
Ma'am, what I hear is a bunch of run-on sentences with a whole bunch of excuses that you think that are just coming into your head at the particular moment. That's what it sounds like to this court. You want to try to throw everything in to see if any of those excuses sticks. Where do you live, ma'am?
974 Eureka, Wyandotte.
Who lives there with you?
Just me and my mom.
Right. Well, your mom's the victim in the matter from just last week. So you won't be returning there, I can tell you that. So where else are you going to live then, ma'am?
I don't know.
What's that?
I don't know.
And who's the victim on the matter that you're currently on probation for?
What victim are you talking about, ma'am?
The assault case in Wyandotte.
I'm sorry.
I don't know.
The jail review. Let me clarify. The jail review.
What assault you're talking about?
For the jail review case.
What does that mean?
The assault that I'm talking about, ma'am, it shows on November 13th.
Yeah.
You have a charge of assault and battery.
How am I charged with assault and battery when I was never arrested for it? I wasn't even home.
Well, ma'am, let me just say this. The police report indicates they were dispatched to the home in regards to a domestic assault. You left the location prior to the officers getting there. And so then they issued you a citation, ma'am. Or I'm sorry, they not issued a citation. A warrant was signed for that.
Against who? My mother who was stage 4 lung cancer, dying? Why would I hit my mother? And I was not even home. How is that even how is that legal? I wasn't even home and I got issued an assault charge because me and my mother got in a fight and I left because I didn't want to argue with
I
her.
wouldn't, don't talk about the specifics of the case, miss.
Where is it that you say that you're working? A dental office?
I have a dental office interview coming up this week, but I was working at PackRate and I had 2 individuals bank fraud my account and I followed up with Ecorse Police and it's still going with that ongoing investigation. At PackRate I was working. They drained my whole bank account, my bank
Okay,
account.
so you don't have a job that you're working, you have an interview.
I was working last month, but I have an interview coming up this week. at a
With the dental
office.
office. Okay.
That's me.
Okay. And so are you out on bond in any other jurisdiction?
No, ma'am.
Have you ever failed to appear in court for any reason?
No, ma'am.
Other than the jail review here?
No.
And
I promise you, ma'am, I'm trying to get my life together. Just I really, my family has been really.
I cannot understand what you're saying, ma'am.
Ma'am, I'm really trying to get my life together. My family and us been really under a lot since my dad committed suicide. I know what I've done. And I'm just asking if you're willing for me to get this opportunity to get this job and let me get my life back on track. I will not come to court.
Excuse me, who was the victim in the matter out of Livonia?
Livonia?
Yes, the stalking. Who was the victim in that matter?
That was my ex-girlfriend, and that wasn't even true.
Okay. Who was the victim? Who was the victim on the matter from Wyandotte that ended up being over at Third Circuit Court? Assault with a dangerous weapon you pled no contest to.
It was my brother. My brother lied against me in the police report. That's when my dad committed suicide.
And then who did the prior domestic violence you have, ma'am? Who's the victim in that matter? From 2018. Who was the victim that time? Was it your mom?
No.
Who was it?
I'm not sure. I don't even remember recalling that.
Okay, given all the pending, the matters on your criminal history, the assaultive nature of your criminal history, the assaultive nature of 251612, and the matters that are pending currently on the 251614 matter with Ms. Jakubiak, the court has some serious concerns. Detective, would you like to address bond?
Your Honor, I do have some concerns about the proximity of the defendant's address and where the incident happened, the victim's address. So I would recommend a GPS tether. And obviously no contact with any victims or potential victims or witnesses in that case, in the felony case today. And I would also recommend a $25,000 10% cash bond, Your Honor.
All right, the court's going to note on 251612 for the reasons this court stated on the record, as well as the concern this court has for Ms. Zamorsky appearing in court. And for the safety of the community, the court's going to order a $10,000 10% bond on 251612. On 251614, the court's ordering a $50,000 10% bond with the following bond conditions. You're not to have any contact with Dana Jakubiak or Gloria Zamorsky. That's phone contact, text message, email, social media, third party, anything of the like. You're not to return to the premises at 974 Eureka nor 1110 Sycamore. You may return to Eureka, the Eureka Road address, one time accompanied by a police officer to pick up your personal belongings. Do not to possess or consume any alcohol or drugs unless prescribed. Do not to possess or have access to any firearms or weapons. And you are not to be released without GPS tether through the Wayne County Jail. Oops, sorry.
So what, my mom pressed charges on me? I can't even talk to my own mother?
Nope, sure cannot.
Thank you, Your Honor.
You cannot talk to your mom directly through a third party or otherwise. Not through writing, not through text message, nothing. No contact.
Thank you, Your Honor.
Thank you, Judge.
Thank you. And just for the record, on the 25443, the court's recalling the warrant and will set this to your review also for November 25th.
This is Demarion Dwayne Kelly. That's you? Yes, sir. With your attorney, Mr. Adams, and the state's attorney. Does the defendant waive a formal reading of the indictment?
Yes, sir.
And the arraignment here. Can we proceed in a summary?
Yes, sir.
Fine. In summary, this indictment alleges that on or about March 30th of last year, 2024, in Jefferson County, Texas, you committed the state jail felony of theft. Do you understand what you are charged with here?
Yes, sir.
A state jail felony means if convicted, you face confinement in a state jail for any term of not less than 180 days or more than 2 years. In addition, a fine may be assessed not to exceed $10,000. Do you understand the punishment rate, sir?
Yes, sir.
An agreement has been reached. Whoa, that was close.
You said it was close, huh?
Yeah, boy, on the restitution, that would have been a third-degree felony for another $1,000 loss. Just come up with number 2 here along with this. Unable to understand the TDW. If convicted of a state jail felony, I told you what the punishment range was. And in this case, an agreement has been reached where you would be sentenced to 2 years in the state jail. That would be suspended. You would be placed on regular probation for 5 years. Most important thing is you got to pay this money back. Whatever happened to the items here? I'm asking you. Where are they?
The person that used me to rent the stuff, they sold it, I guess. And I didn't realize that till later.
Oh, so you're not guilty?
I'm not saying that. He's guilty.
I am, but
He worked with us.
Yeah, I am, but it doesn't get it, sir. You're either guilty or not guilty in this room. You don't, I'm not guilty, but no, you're either guilty or not guilty. If you're not guilty, we'll have a trial. That's what we'll do and let a jury decide. They don't give probation. No, I just, look, you're hedging. You're hedging. You're charged with theft. You're not going to trick me or try to deceive me. You may try to deceive others here, but no, I've got my hand on my wallet at all times here, keeping it safe. Sir, you're being a smart aleck, is what you're being, sir. I've asked you what happened to this. What I want is the people to be paid back for their loss. If you have the item, I want you to give it back to them, whatever it is you rented.
It's heavy equipment.
Whatever, I'm still unclear. Where did it go? You give it back to them, you don't have to pay restitution.
He said it was sold.
You sold it to somebody?
I didn't sell it. The person that went to jail for it sold it.
There was 2 people involved.
I was used to use my ID to rent the machine, and I didn't realize till later that what I was doing was totally wrong. Uncle, I don't know if Beaumont picked him up or whoever picked him up, but he was currently in jail for it now.
Who?
You want to know his name?
Oh, Jerome Daniel.
Did he get charged?
Yes, sir. So,
Is that in my court?
I don't know.
Jerome Daniel?
What's it up?
Last name is Daniel.
Daniel.
Very. That's your heart.
I'm not seeing it either.
That don't work. Try Jerome Terry Denton. So,
ERRY.
yes, ma'am.
What does the state have in your file on evidence in this case?
Your Honor, we have the contract from JAC Rentals where this equipment was.
May I see that? What else do you have in there?
An office report, photos of the materials.
Driver's license? Worst thing you can do is attempt to mislead me or stand up here during any process that we handle in this court and make a false statement. That would be the worst thing you could do. Well, I'm going to find out if you did that. Because it's somebody else who used your ID is what you've told me.
Yes, sir.
We'll see, because they say it was you in this affidavit.
Yeah,
It's not a debate. I'm going to just let me get the information and what your story is you had no knowledge that somebody else was going to use your ID and rip this, correct?
Yes, sir.
So quite naturally, you got indicted by the grand jury for no reason. Let's see how that plays out. Because the worst thing you can do is get caught in a lie in front of me. What's his bond? Just false statements to this court are crimes.
$5,000.
Your Honor, I have the contract with his contact information, but I'm not seeing a copy of his driver's license.
Give me your driver's license.
Oh, it's in the car.
Go get it.
Do you have media?
Yeah, I do have media.
And come right back, or else a warrant will be issued for your arrest. Thank you.
I was at their I was actually this morning in the first. So entirely different. But the kids all the changed that. If it's a problem, it's actually excited. So those are the quite a lot of signs in the you get some media on down here, how on the back?
Huh?
Guys, let's look at it this way. We're already outside of 10 days. Let's look at it and see if we can get it in and hey. The present sense impression or saying they don't read moments. So that is really good job.
Yeah, they've got this is the same one they have a copy of. They used this was your ID that the state had. That's the same one. That's you.
I just don't like that. We're trying to check on the media, judge, see if there's any videos of the transaction. Give us a minute.
She has a copy of his ID already.
Oh,
they have a copy of it.
It was in the box?
Yes, it's
It's the same. It's the same
in the
ID
discovery.
that
And it's
that was used, and that's the one that was
the
used.
driver's license.
He was in there. That was him
as well.
not somebody else. That was him.
Are you accepting responsibility?
Yes, I was just letting them know that that's all.
No, you were letting me know you weren't guilty of this crime. It was somebody else's fault. You didn't know what was going on. That's what you. I'm sorry.
You gotta accept responsibility.
Okay.
Did you do it or not, sir? Did you go in there and rent this thing?
Yes, I will.
So why would you have said otherwise to me? Why would you have said it was somebody else? My goodness. First thing to fix any mess is to be honest about it. Don't compound the problem. All you did was throw gas on a fire that he's trying to put out.
Yeah.
Yeah. The agreement that has been reached here is that you would be pleading guilty, sentenced to 2 years in the state jail. That would be suspended. You would be placed on regular probation for 5 years, ordered to pay restitution in the amount of $29,000. Is that your understanding of the plan here?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand? How do you plead to this, guilty or not guilty? I didn't hear. Are you pleading guilty voluntarily and because you are guilty? I'll show you what's marked here as States Exhibit 1. You just sign that document voluntarily. Understand it, discuss it with your attorney, or the contents all true and correct.
That's your signature, please ask. No. Yes.
Is everything true and correct, Will?
Yes.
States Exhibit 1 is tendered into
No.
without objection. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with, and the indictment's been read to you, or you've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination, and this is you were totally satisfied with the representation provided by your lawyer. All of this is true, so help you God. States Exhibit 1 is moved into evidence without objection.
No objection.
It is granted and allowed and admitted. Pre-sentence report is hereby waived.
Yes, sir.
If nothing further to add, I'm going to follow this agreement. I'm going to find Mr. Kelly, you are pleading guilty voluntarily. You're mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from States Exhibit 1 admitted here to find you guilty beyond a reasonable doubt, and I am following this agreement. I find you guilty beyond a reasonable doubt of the state jail felony. You are hereby sentenced to confinement in the state jail for 2 years. That term of confinement is suspended. You were placed on regular probation for 5 years. There will be terms and conditions of probation which you must follow. Failure to follow these can result in revocation of your probation, and you can be placed into the state jail up to 2 years. The most important term, the two important terms: don't commit any more crimes. Number one. Number two, pay these people back. You must pay $29,000. How are you going to do that? Do you have a job now?
Yes, sir.
What do you do?
Warehouse ops.
Okay. How much do you make an hour there? I'm sorry?
$15.
That's about $30,000. Do you have a family at home, or is it just you that you take care of?
This means
Okay. How much are you able to pay per month toward this restitution? This $29,000. That's not going to happen overnight. What can you pay per month? Okay. You know how long that would take? 23 years. Is that how long you want to be on probation? You have to speak up. She can't put a nod or a shaking of the head. No, you have to speak up. We got to communicate here. Is $100 the most you can do?
200.
Can you? No. Don't put more than you can. Don't stick your neck. If you fail to pay in this, you made a mess. You're trying to fix it. Don't make it worse. What's realistic? 200? 200 is realistic. That's still, that's 2,400 a year.
Yeah.
And at 29, that's still 10 years or 12 years. It's a start. All right, what else? Anything else from the parties?
Nothing to state, Your Honor.
All right, please see this lady. She's going to go over all the terms and conditions of probation. You will begin probation. Thank you.
Right here.
Center. Mr. Augustine, good morning.
Good morning, ma'am.
Are you, is there an officer in the room with you?
Yes, ma'am.
Hi, I'm Tanya Stevenson, the transition specialist.
All right, thank you, Ms. Stevenson, for accommodating us this morning. So, Mr. Augustine, would you introduce yourself, tell us your name and DOC number?
I'm Anthony Tyrone Augustine, DOC number 430160.
All right, Mr. Augustine, I'm just going to read some identifying information into the record. I'll ask you to verify if it's correct, and then I'm going to turn it over to Mr. Prater, seated to my immediate right. Your case has been assigned to him, so he'll take it from there. You ready?
Yes, ma'am.
All right, Mr. Augustine, you're here this morning seeking a commutation of your sentence. You were sentenced in the 12th Judicial District of Boyles Parish in August of 2000. For a manslaughter conviction, you received a 40-year sentence. You do have a good time date, which is December 23rd, 2033. Is that information correct, sir?
Yes, ma'am.
All right, Mr. Prater.
Okay, Mr. Augustine, how are you today?
I'm okay, sir. How about yourself?
Okay, I'm doing good. I'm doing good. Thank you for asking. Okay, we've got a number of people here that are in opposition, and we'll get to those in just a minute. But what we like to do as a board, we like to find out a little bit about you and a little bit about your history since being incarcerated, how you've done, and what you think about the crime. And then we want to hear from somebody from Catahoula there, if there's anybody there that would be willing and knowledgeable to speak about your behavior at the institution. So to begin with, Mr. Augustine, would you tell us what got you put in jail and what you think about the crime and what you've been doing since then?
Well, February 2021, I committed a horrible crime that, I wish I could take back, but I took the life of a mother, a daughter, a sister, a friend, and I hold myself accountable for the actions that I have done. But since my incarceration, I have taken numerous classes, substance abuse, anger management, cage and rage, thinking for a change. I have several Bible courses at colleges that I've completed and graduated from, GED. But like I said, I'm holding myself accountable for what I have done, and I have worked hard constantly and still working daily to become a better person, a better man, a better brother, a better father, a better friend,
Okay. All right. Well, that pretty well wraps up your statement. You've covered all the high points of what I wanted to hear. Let's hear somebody from Catahoula. Who's in the room there with you? I'm sorry, I missed the name.
Tanya Stevenson, the DOC transition specialist.
Yes, ma'am. Do you know this fellow very well and how he's behaved since he's been there, and how long has he been there?
I'm not sure how long he's been here, but he has no behavior problems. He was a trustee here at the main facility, but he's at the parish jail where he is a trustee there.
Okay. All right. Well, thank you. I appreciate that information.
You're welcome.
Okay, well, let's move on now to those folks. We don't have anybody speaking on your behalf that are signed up to speak, but we have a number of people to speak against this request for a commutation of your sentence. And so we'll begin. We have three people that will be speaking. We have Kia Greenhouse Allen, we have Cheryl Lewis, and we have Casey Greenhouse. They will be speaking. Now, there's a number of people that are here in attendance, and I don't know if you can see them or not, but it's J-Nex Greenhouse Jr., LaShawn Dixon, J-Nex Greenhouse Sr., Marie Jacobs, Chiquita Greenhouse, and Kim Greenhouse are also here, but they will not be speaking. They're just here for support and or support of each other, I would say in opposition of your request. So between Kia, Shara, and Casey, I will let y'all decide who will be first. When you speak, would you go to the podium? Please speak up so we can hear you good here at the board and on the microphone, and tell us what you have to say as far as your opposition. So whoever would like to go first, please introduce yourself.
Hi, I'm Sheree Lewis.
Okay, and let me apologize. I'm sorry, you were on Zoom, and I was introducing the folks that were here also. Yes, ma'am, you're on Zoom, and introduce yourself again.
My name is Sheree Lewis.
Okay.
And I'm Sabitra's best friend.
Okay. And tell us why you're in opposition for this.
Basically because and I hear when he says that, yes, he want to change, that he change and becoming a better person. But on the other end of it, he gets a second chance. Like he gets a second chance at life or whatever. My friend don't get a second chance. And he was selfish. I mean, he took a selfish move. You took her because of being selfish. And you left her child there with her. And yet you think you deserve another chance, which, no, I'm not God and I'm not doubting that, but I'm just totally not for it. No.
Okay. All right, Miss Lewis, we appreciate you taking time to give us your thoughts on this. Miss Allen or Miss Greenhouse, who would like to go next?
I'll go next. Hello,
Okay.
my name is Kia Greenhouse Allen. I am the cousin of Sabitra Allen. I wrote a statement. I would like to express my strong opposition to the potential parole of Anthony Augustine for the murder of Sabitra Greenhouse. His actions not only resulted in the tragic loss of an innocent life, but they also left a lasting void in the lives of her daughter, Casey, and our family. Sabitra was murdered in her parents' home, a place that should have been a sanctuary. With this brutal act, Anthony robbed his child of her mother, leaving her to grow without the love and guidance that every child deserves from their parents. This senseless act of violence not only affected the victim, but has had a profound and painful impact on our entire family. Anthony does not deserve a second chance in society. His crime was not just a moment of anger. It was a calculated decision that shattered so many lives. I can never forget the words of the priest at her funeral. He stated that these were not the actions of a man, but that of a beast. The consequences of his actions are lifelong and cannot be undone. I urge you to deny his request for parole, as releasing him would bring injustice not only to the memory of Sabitra, but also to our family and the community that continues to suffer from this loss. Thank you.
Okay, thank you, ma'am, for taking time to be on Zoom with us, and we'll continue on then with the opposition. Now, Miss Casey Greenhouse, who is here at headquarters. Miss Casey, would you go up, Miss Greenhouse, would you go to the podium? There you go. Introduce yourself and tell us what's on your mind.
My name is Casey Greenhouse. To the honorable members of the Louisiana Clemency Board, my name is Casey Greenhouse, and I stand before you as the daughter of Sabitra Greenhouse, who on hate crime was committed against on February 21st, 2000, at the age of 18, by my biological father, Anthony Augustine. I am here today because my father murdered my mother. I was only 6 months old. The story I have of that horrific day is that my mother was sitting in the same room with me, working on her schoolwork so she could graduate high school and create a better future for the both of us. I was told she was young, hopeful, and determined. She was doing everything right, working hard for her life and for mine. But all of that was taken from her when he I was left in the room beside her lifeless body. I was found only because my aunt unexpectedly became ill at school and had to return. I cannot imagine how long I would have remained in that house, alone with her if my aunt had fallen ill that day. That is how my life began, not with safety, not with love, with violence, trauma, and a state of experience. My 6-month-old life began with the loss of both my parents because of his choices. I grew up without a mother and without a father who should have protected me. I spent my childhood wondering what my mother's voice sounded like, what her laugh sounded like, whether my smile looked like hers, whether my shit came from her, there was, and basically, but I would never know because she was silent before I ever had to remember her. My mother never had the chance to record videos, take pictures, or leave behind the way people do today. One of the most painful of many things I grew up with was the longing to hear my mother's voice. I would wonder what she sounded like, and then it would hit me. At least he still has a voice to this day. Yet my mother remains silent and forever will remain silent. No videos, no saved messages, nothing. I grew up watching other children make Mother's Day cards, but I had no one to give one to. I watched other girls have their hair brushed by their mothers, get help picking out dresses, get cheered for school sports graduations. I never had any of that because I was robbed from my mother. She wasn't there for any first days of school, my birthday, my heartbreaks, my first job, my college applications, my adult decisions, any milestones that should have been shaped by my mother's love. She should have been here. She should have been there for my wedding one day. She should have been there to help me prepare for motherhood when the time comes. She should have had a chance to be a grandma, but she won't, because that was taken from her. Every single holiday, celebration, and ordinary day has been marked by her absence. I grew up emotional anxiety, sadness, and a deep abuse that words can barely describe. My entire identity was shaped by a crime I did not choose, a loss I could not stop, in a moment I was too young to remember, but will spend the rest of my life feeling from. Ag did not just take my mother's life, it destroyed 2 families. My grandparents, aunts, and uncles raised me. Their own grief walking on eggshells, so they didn't speak out of anger about my father. For 26 years, emotions, trauma, and unspoken pain were bottled up so that they would not hurt me further. They had to comfort a crying baby one morning their murdered daughter and niece. No family should ever endure that. His family suffered because of his choices. They lost him as well. This was not just a crime against one person, it was a wound that spread across generations. In 2015, I received a letter, and in that letter, there was no apology from my father, no explanation, no accountability. Nothing that acknowledged the lifelong pain, caused by choices. Wrote that you love me, but I must ask, how could you love me, left me alone in a home with my mother's lifeless body? Where was the mercy in that letter for me? Where your actions? There was not a sense of remorse to that day that could be sensed at any point in that letter. How could you claim you love me while abandoning me in the darkest, most terrifying moment a child could ever experience? Growing up, when I struggled through depression, while wondering why not me instead of her, and even worse, I feared that when you got out, you might come back and finish what you started. That fear existed and continues to exist because of what you did. How can I form a bond with someone who never cared about me from the beginning? How can I trust you? How can I open my life to someone who hurt my husband in front of me and abandoned me immediately after? It loved me so much, why did you just walk away from the relationship? I think you choose freedom and raised me like a father should. Instead, you chose violence. You chose this. You chose to destroy our family and the future I should have had. And now we're here. For your child, your daughter, forced to stand before a clemency board, begging, pleading, fight for her mother because of the actions of her own father. I'm pleased to agree your release or to do any kind of bond with someone who never cared about me from the beginning. Someone who brought everything that mattered the most in life. That is not love. Today, the man who caused all of this pain is asking for clemency, asking for mercy, but I ask this board, why was the mercy for my mother? Why was the mercy for me? The 6-month-old baby left crying beside her body. Why was the mercy for either of our families who have carried this trauma for decades? Mercy was never granted to us, to her. Why should it be granted now? Where was the clemency when she was carried by 6 while you were still breathing and had opportunity to be judged? Clemency cannot bring my mother back. It cannot restore the life she was building. It cannot give me the childhood I lost. I never heard, or the memories I never got to make. Instead, her questions destroyed our created generational trauma and forced me to lifetime and I answer questions. For 6 years, I've lived in an emotional roller coaster, begging, pleading, and fighting for justice for my mother because the person who should have protected us chose not to. This has shaped our life, and today I speak it to honor what we lived through and ask for justice that reflects that reality. Great mercy, not be justice. It'll be different to the lifelong consequences of this choice. Clemency cannot undo what was done. It cannot bring my mother back. It cannot give me the chance to hear her voice, to hug her, to know her love. Granting clemency in this case would not be just. It would erase accountability for a choice that was most selfish and irreversible. I have lived every single walking day with the weight of this tragedy. For all these reasons, I stand before you, requesting you to honor my mother's life, honor her dreams, honor the silence she left behind, the silence created by violence, not choice. Let justice remain firm because of mercy. I restore the once. I respect from the earth's support to deny clemency. That is the only mercy that remains. Let justice remain firm because mercy was already stolen from us the day she was murdered. I would like to thank you all for this opportunity to stand before you and have with my mother.
Good job.
Thank you. Thank you very much for the reading that to us. And we also have been supplied that letter and read it. And I honestly had to take a break from studying my cases after I read that letter because that was tough. Well worded and good letter. So thank you. And while I'm talking to you, I'd like to give a special applaud or whatever to your grandparents, the ones that raised you, stepped up for you. You had wonderful support. Okay, back to you now, Mr. Augustine. I guess you heard what your biological daughter had to say. And before we get into this part, which is the question and answer session from the board, but I'll leave that off and then we'll see if they have any questions. Also, I want you to understand, we have read your file, so there's a lot of things that didn't come out in our interview. The fact that you are a first offender, I want to acknowledge that. This was your first felony arrest, that you did get your GED You said that in your opening statement, but I saw that and I was particularly impressed by that one of your supervisors there in the work release, I believe it was, but the security supervisor there did write a good letter since they've known you, which is the time you've been incarcerated, that you've been a model prisoner. And I know that, and I can look at your face and I can tell that you are remorseful in all of your statements. But also you need to know that the DA, the sheriff, and the sentencing judge were all opposed, and all of the victim family was opposed also. So anyway, I don't really have a lot of questions to ask you. You got a 40-year sentence on a plea bargain, correct?
Yes, sir.
Okay. And you served how many of those 40 years?
25 years and 9 months.
Okay, and you'll be getting out, a good time date is in 2033, regardless of our decision today, correct?
Yes, sir.
Okay. I don't have any other questions.
Just got one question. I saw you lost 45 days of good time, but I didn't see no DB reports. What you lost that for?
Well, I got transferred to Williamsburg, Franklin Parish, in a 6-man cell. And they came down a shakedown because they got a tip that a guy had a phone. So when they found the phone in the cell, there's nobody on up to the charge, but everybody got charged
in the cell.
But I got it restored, and when I went to court, I beat the charge, got dismissed, and I got the 45 days restored.
So it wasn't drugs; it was a cell phone.
Yes, sir. But on my route sheet, I have it. It showed that it was restored because it was.
Yeah, I see that.
Yes, sir.
Okay. All right. Is that all you got, sir?
That's it.
Anybody else got any questions?
I got one. I got something that I noticed on your commutation application, which goes back to, I didn't hear you say you took any crime victims awareness classes when you were talking. I might have missed it or something. Did you get anything that said crime victim awareness?
No, ma'am. The facilities that I was at, they didn't have that program, that class.
Okay. Well, I did notice that after all these years, when you put in for your commutation, it asked what was the reason, in your own words, for the offense. And one of the things that you say is because I just couldn't bear having my only child taken away from me for no reason besides her daughter's mother being spiteful. So, I don't know.
I don't remember. I don't recall that right there.
You don't recall that? Well, that was part of your statement. So maybe you want to kind of rethink that. That was something that stood out to me. Okay, thank you very much.
All right. I don't see any other questions, Mr. Augustine. So I think we are prepared to vote. Mr. Prater voted first. Okay, because of the victim opposition, which was very touching because of the other law enforcement opposition, because of the fact you took a plea bargain and because of the fact that you don't get out earlier than expected anyway, and you took a plea bargain 40 years and you took someone's life, I don't think you've served sufficient time, although I want to tell you I'm impressed with your behavior and the efforts that you've made there, so I don't want to leave you without hope or anything, but I do honestly feel like that you need to go ahead and serve some more time. Mr. Freeman?
I concur with Mr. Prater.
Mr. Tillers?
I agree with Mr. Prater.
Mrs. Stapleton?
I concur, Mr. Prater.
All right, Mr. Augustine, received 4 votes to deny your application today. So today your application for commutation has been denied, sir. Good luck to you.
Well,
older than me.
Well,
and I'm old.
It's because you're so young.
This was, you know how old this thing is? You had hair.
Yes,
you had hair. Oh, when this was filed.
You missed this, haven't you? So
good to pass that up.
We have, I appreciate it.
How's it? We had a meeting.
We have
talked to him.
Yes, Judge.
How's that going?
It's cool. Great. That's great. We have worked out a deal, we believe, for the state. It's going to be a little bit unique from what we normally do, but we've agreed.
What else is new here in this room?
Yes, Judge.
It's a unique kind of place.
So what we would like to do is enter a plea with you today, and with an agreement about the outcome. But what we have a dispute about is about the restitution. And the amount of restitution ultimately impacts the level of offense, if that makes any sense.
Yeah.
And so what we would like to do is have Ms. Gallagher plead no contest today to the offense, with the caveat that she, at sentencing, we would have a separate hearing for appropriate restitution. So that we can get that sorted out. We have a dispute about, and a significant dispute about the restitution.
Well, let me just look at one thing. It's a small problem. Short of it. It does state a significant amount of cost, doesn't it?
I think it'll be significant in either direction, but I think there's also a significant difference between what we believe is correct with the and the selection.
We're a little wordy, interrupting over and over again on this. Is there anything you want to add?
No, Judge, we've talked about this. We do believe that the restitution is as alleged, and Mr. Kurtz is saying otherwise. So if we need to have a hearing on the amount of restitution.
There's an issue to the amount, but
I'm going to object to that.
Is there money still available to be paid?
Judge, our intention was to, we have a number in mind that's, again, a substantial number. Our intention would be.
No. Is there any loss somewhere circulating that has not been disposed of that can be returned?
That's what I was going to tell you, Judge, is that our intention would be to deliver a check for what we think the correct amount of restitution is to the district attorney's office, or we could put it in the clerk of the court or whatever. But that way she's making a good faith effort, and then we can present our case about what we think it is.
A victim can get anything back because there's not an interest charged on this, like was done when I was in federal government. The federal government is different on that, which I think is the best way, especially hearing from victims. But if there's something that is available that can be returned, the quicker that is done, the quicker this court is more satisfied, because that is something, because every moment the entity or the person here who is out the money, I mean, every day, if they're out and they could have had something, it's something they can use because they're out. These assets that can be used at their discretion, which is the way it's supposed to be since it's theirs. Was the money transferred into other forms of value, like property or things like that?
No, Judge, but we've got access to funds that we're going to provide as part of our effort to make a restitution book. But again, in the amount that we think.
I know, but it's still cryptic. Where did it go? What happened?
Well, Judge, this is an allegation involving like 11 years.
I know, but what happened?
I don't know all the details of where the money went. What I can tell you is it's not like she owns a beach house or something with it. But she's.
Was there an illness in the family or something? Yeah. What I'm looking for is where, those kinds of things that there sometimes it certainly goes to the point of whether there was vindictiveness or somebody was facing duress.
I anticipate
that's a lot of money. That's $750,000, right? This is what this says. $768,000 is what it alleges in the probable cause affidavit.
Okay, we disagree with the amount.
That's okay, but I'm just saying what this states. Generally, they're accurate or close. But if you're saying it was $51, I'd like to know what the heck. is the difference, you
Yeah.
know? But it didn't go to somebody's illness or to save a life or anything like that, as far as you know? Okay. No. All right. 2241053 then is called. You were Sabrina Gallagher?
Yes,
And you were here with your attorney, Mr. Gertz, and the state's attorney is here. There is an indictment, man, that was handed up a long time ago and over 3 years now. So it's time this moved forward. And does the defendant waive a formal reading of this indictment? And can we proceed in summary?
She will, Judge.
In summary, this indictment, ma'am, alleges that from on or about April 1st, 2014, and continuing until on or about December 7th, 2020, which is given a 6-year range or so, that you unlawfully appropriated by acquiring or otherwise exercising control over property, namely money, from the victim in this case, with the intent to deprive the owner of that money, and the aggregate value of the property obtained was $300,000 or more. Do you understand what you are charged with here, ma'am?
Yes, sir.
And in theft, the punishment range is primarily based upon the amount at issue that is either lost or otherwise acquired. And this, it becomes a first-degree felony if the value of the property taken or stolen is $300,000 or more. So that's what this alleges as a first-degree felony. It's a second-degree felony if it was $150,000 or more, but less than $300,000. And then it becomes a third-degree felony if the amount taken was $30,000 or more, but less than $150,000. So you can see each tier level steps up from what was a third degree up to a first degree that we talked about. And then a state jail felony if the property is stolen is $2,500 or more, but less than $30,000. So those are the different 4 levels of felonies. So you know where all of this fits. So right now it's alleged as a first degree felony, which carries with it, if convicted, no less than 5 nor more than 99 years confinement in prison or life in prison, and a fine up to $10,000 can be assessed. Do you understand? Mm-hmm. Is there a pad?
Because we haven't filled it out yet.
Oh, I thought you were going to enter a plea.
Well, that's what we were telling you what we were doing.
We just
ready to go.
We just wanted to see the best way to.
So you're going
to
prepare the documents here.
Yes, Judge.
And
also
then
the cabinet's locked, so I couldn't get in there.
All right. Then let's.
Can you get the key out of the?
I'll get it. Let's get that done. And then, so we enter a plea, pre-sentence report gets prepared. What do you want to do next?
We're going to have a restitution hearing at the time of sentencing.
Okay.
And we have an agreement as to the punishment that it would be 10 years deferred. Again, what we don't agree on because of the restitution.
What's the victim say?
I have spoken to the victim. He's okay with that. He would like to get his money back.
And what are we talking about? How much is going to be forthcoming to tender?
A substantial amount of 6 figures.
Okay. Let's try to get as quick as possible. Well, because again, we're talking about years that this money has been displaced and at a marketable interest rate. That's a lot of money that would be added to the loss. That's their assets that they could have used for something on their behalf at their request, not without their permission, you know. That's all. I reward people to fix the mistakes as soon as you can and to the amount as high as you can. Okay, please prepare that. And we'll go through the pleas. We now call cause number 22-41053, the state of Texas versus Sabrina Gallagher. Present with Mr. Gertz, her attorney, and the state's attorney. Does the defendant waive a formal reading of this indictment and the arraignment here? Can we proceed in summary?
She does, Judge.
In summary, this indictment alleges that from on or about April 1st, 2014 and continuing until on or about December 7th, 2020, it was like a range of 6.5 years, it looks like, that it is alleged that you acquired or unlawfully appropriated or otherwise exercised control over property, namely money, from the owner of this entity with the intent to deprive the owner of the property, and the aggregate value of the property obtained was $300,000 or more, which constitutes the first degree felony of theft. And this was a set of tanning salons, I guess, from what I've read. Do you understand what you're charged with here, ma'am?
Yes, sir.
And a first degree felony, you've talked about that. If convicted, you are facing no less than 5, no more than 99 years confinement in prison or life imprisonment, and a fine up to $10,000 can be assessed. Do you understand?
Yes, sir.
All right. This is what the indictment says. There's an asterisk here on the punishment range, and we're going to have a hearing on the amount of loss so that we will be able to know exactly where this proceeds. But is it the plan from the defendant and the state that the defendant is committed to admitting guilt in this theft case to whatever level it is deemed that the restitution resulted in, which the court would make a determination of at a later time when all parties have a chance to present evidence.
Right.
And then what happens there after that? Let's say it's determined. Then what is going to happen?
Judge, our intention had been today to enter a plea of no contest to the indictment and then have that restitution hearing, and at which time the court would determine which level of offense and what amount of restitution is necessary to be paid by Ms. Gallagher. And to clarify, I've also gone through in the paperwork with Ms. Gallagher each of those different punishment ranges from first degree, second degree, third degree, as potentially applicable to her outcome.
It also doesn't change the state's offer, regardless of the punishment range changes, but the offer in the case remains the same.
Which is
10 years deferred.
Okay.
And
the plan
amount of
is it's
restitution
going
will
to
be
be disposed of in a deferred or unadjudicated fashion, and the defendant would be placed on probation for up to 10 years in length. And the problem is that if you fail on probation, it could be catastrophic, to say the least. Now, you could be looking at up to life imprisonment, depending upon what level it is the court deemed restitution is. So that will be the first step. We'll have a hearing later on, and then we will take up the matter of disposition.
Yeah, she signed
But
the document on there.
has Mr. Gertz gone over with you every level of punishment range options, which are dependent upon the amount of loss, which is still yet to be determined? We will have a subsequent hearing on that. Are you familiar with all of these levels? Do you understand fully what the ramifications are? Again, the punishment range will depend upon the restitution that the court deems appropriate after the subsequent hearing we're going to have on that. And then you would be placed on deferred or unadjudicated probation, where you are not found guilty and it would be up to 10 years in length. And needless to say, restitution will be a necessary element if you were placed on probation. And the timeliness and the amount that you pay back have a lot to do with other factors that will come into play on conditions of probation. And if you're placed on probation, there will be terms and conditions of probation, which are not only normal, most of which are normal and customary for probationers. But in your case, if there's an amount of restitution still remaining, that's going to be foremost on this court's concern, to get paid back as soon as possible, for which timeliness of doing that, putting the victim back whole, is in your best interest, plus it is rewardable, as this court has always historically done, by people paying back timely and getting that back to the victim. Because every day the victim is out, and we're talking about several $100,000. Every day they're out that money to use. It's an interest and a value that they don't have that costs them. And so they continue to be punished. So, and that's the way you fix it, is paying it back. Yes. Unlike if you break an arm, you can't unbreak it. It might heal back to some degree, but it's still broken. Here, you pay the money back. All right. So you've gone over the different punishment range. You know what the circumstances are in this case. If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes.
How do you plead to this indictment charging you with theft? Guilty or not guilty?
No contest.
I know before. If you have the right attitude, you don't space.
Stand by.
You do kind of have to be. Oh, thank you. Oh, all right.
You can't be easily. It says that to us.
Well, that's what it said.
No contest. Do you understand, or are you making that plea voluntarily, knowingly, intelligently, and based upon discussions with your attorney? Do you understand that a plea of no contest plus supporting evidence to that plea that the court will allow subsequent to this, or today if you want, but that would be enough to find you guilty it could be enough to find you guilty if proven beyond a reasonable doubt. And it has all the same consequences as a plea of guilty, but it cannot be used in other types of courts, such as civil courts. If a lawsuit was filed, then a plea of no contest, it would take more than that for a disposition to be rendered on behalf of a plaintiff suing you, for example. But otherwise, pleas of no contest in this court end up criminally, in the criminal end, having essentially the same consequences. You can be found guilty beyond a reasonable doubt. Your probation, we will be putting you on, if all of this works out, the deferred or unadjudicated probation is going to be pending failure to follow the terms and conditions of probation, which are similar to all other types of probation, are required. Failing to do that could result in a motion to revoke probation being filed. Then a finding the court could make, if proven legally, where your probation has failed and by conditions of probation, and you could be revoked, then found guilty at that time beyond a reasonable doubt, and then sentenced up to the full range of punishment, whatever this becomes after the pre-sentence report is prepared. But once again, going back, these terms and conditions of probation, the most important one is going to be restitution, especially under these circumstances where there's such a large amount of loss. I want the victim placed back in as whole a position as possible under these circumstances as quickly as possible. Do you understand my sense of urgency?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes.
And again, how do you plead? No contest, correct? And you're doing that voluntarily, knowingly, intelligently, and because and based upon discussions with your attorney, understanding that it can have the same consequences as a plea of guilty, except for the other reasons that we went over.
Yes, sir.
I'm going to show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it, discuss it with your attorney, or the contents all true and correct? State's Exhibit 1 tendered into evidence and without objection.
We have no objection.
Admitted. Among other things, this states you are mentally competent to enter your plea of no contest. It is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are pleading no contest to it voluntarily, knowingly, intelligently. And you are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All true, so help you God, it states. Correct?
Yeah.
State's Exhibit 1 is made a part of the record for all purposes. Is there anything we need to do today?
No.
Nothing else we're going to do today. We're going to reset this for a pre-sentence report. Then come back, and then we will have the other parts of this hearing that need to be addressed because there needs to be some evidence placed on the no contest to support a court's finding based upon because we're not pleading guilty. It's still there has to be something that supports the plea of no contest so that the court can make a finding beyond a reasonable doubt.
That's correct, Your Honor. We believe that the witnesses that will call for the amount of restitution will also support that finding as well.
Okay, what is the date?
December 18th.
Okay, December 18th.
Thursday.
How's that doing for, okay, what are we doing about return of money?
Judge,
of some sort.
We're going to make a substantial payment
on that day.
In advance of that day. Yes, Judge.
Okay. Oh, you're doing it before that day.
We will have it done by that date. Yeah.
Okay.
And then the amount of remaining restitution will be determined at the hearing.
Is there an idea in mind about how much we're talking about?
Again, Judge, it's a six-figure number.
Yeah, that's it. Okay, there's only 1 million of those. Or I'm sorry, 999,999 of those.
I'm on it.
Okay, it's still being. It's probably. It's
still
you're
being
saying
calculated.
you don't want to show your cards yet because you're still calculating.
Correct.
Thank you. I'd like to know about what that is as soon as we can. So we got a hearing coming up on the 18th.
Yes, sir.
All right, of December, and the victim at least will somehow have some recompense on or before that date to some degree that you're saying you're contending is a substantial amount.
Yeah.
Good for everybody. All right. Anything else? Then we're in recess.
We're here today for sentencing. At the last hearing on June 9th, we were supposed to have her sentenced. She failed to appear. It's the state's understanding that the PSR has not been completed, which would lead only to a prison term being imposed in the state of Ohio. I would ask you to impose it. Thank you.
Thank you. Thomas, is there any reason not to go forward with sentencing?
Your Honor, Ms. Tankersley would like to request that the court to give her time to complete the pre-sentence report. I understand that she did fail to appear back in June. Your Honor, I did try to contact her. We were never able to touch base, so she would just like to ask the court.
Why would I do that? She was told if she didn't show up that I couldn't consider probation, and I wasn't going to consider it, delay the sentencing any further because she decided not to show up. She's been through this plenty of times. Why I don't get why I should do that. You made a choice. You made a decision. You chose not to show up. So that request is denied.
Okay, thank you, Your Honor. With that being denied, we would be prepared to proceed with sentencing.
All right, is there anything you want to say on behalf of your client?
Yes, thank you, Your Honor. We would just like to ask the court for the minimum prison sentence today. Your Honor, prior to all of this, I had many conversations with Ms. Tankersley. She did have every intention on completing it, so I don't fully know her circumstances of not completing the pre-sentence report, but prior to all this, Your Honor, she was trying to get her life on track. She was attending school. She's still attending school. She does have 2 years left on that. So, Your Honor, we would just like to ask the court for the minimum sentence today. Thank you.
Thank you. Tankersley, you have the right to address the court before your sentence. You can say anything you want. Is there anything you want to say at this time?
Dr. Sam.
Whatever you're comfortable doing.
I would just like to apologize for not showing up for court. However, I was with the flu.
That was 6 months ago.
Yeah. I had the flu.
For 6 months?
No, not for 6 months, but when
Did that
the
prevent
court
you?
date.
Did that prevent you from picking up a phone and dialing a phone number?
I did call Nicolette a couple of times.
No, I'm talking about back in May when you weren't supposed to, when you didn't show up and you couldn't make it because supposedly your ride wasn't available. Did you call probation and tell them that?
No, I did not.
Well, go ahead.
But I apologize for not showing up for court or calling probation. I don't know. I'm sorry.
Thank you. Ms. Thomas, is there anything else?
No, Your Honor. Thank you.
Mr. Geiger, for the state of Ohio.
Thank you, Your Honor. The state of Ohio understands that the lack of a PSR in this matter is this court's unable to hand down a sentence for community control sanctions. We just ask that you give her an appropriate sentence. Thank you.
Thank you. Ms. Randazzo, how much credit is there in this case?
4 days, Your Honor.
1 day originally, and then 3 since she's been arrested. This court has considered particular facts and circumstances of the offenses involved, the nature of those offenses. I did order a pre-sentence report and investigation. However, the defendant failed to appear at the probation department for her interview, so that was not able to be completed, so I don't have that to consider. Though I have considered the defendant's prior criminal history, as that has been provided to me. Consider what's been said here in court. All this was considered in the purposes and principles of felony sentencing set forth in 29-29-11. For the factors in 29-29-12, nothing stands out factually indicating it's more or less serious. For the recidivism factors, almost all of these are present. The defendant has an extensive criminal history. She's previously served multiple prison terms. She's been on probation before. To me, in the past, has violated her probation multiple times. So she has not complied with previously imposed sanctions ordered by courts. It's a drug abuse problem that relates to the offense, and she's not getting help for it, and not even doing what she needs to do to put herself in a position to try to get help for that. She claimed that after she pled and she went to the probation department for the initial referral, that since this incident happened, she's been making the effort to change her life around. Yet you showed up, tested positive for drugs, so I'm not sure what effort was made there. No genuine remorse. She violated conditions of her bond again in using drugs while on bond and failing to show up for court. She didn't appear for her sentencing hearing.
I apologize. I'm on call, Your Honor.
Well, that doesn't matter. When you're in court, that doesn't excuse that.
No, I understand.
No factors indicating recidivism is less likely. Under 29-29-13B1, court finds the defendant previously served a prison term. Further, that there was no pre-sentence report able to be completed because of her not showing up when she was supposed to. Therefore, the court doesn't even have the authority to impose community control. Prisons consistent with the purposes and principles of sentencing. And the defendant's not amenable to any available community control sanctions. Previously, this court has sent Ms. Tinkersley to prison on a couple of occasions. And there were significant stints in prison. That didn't seem to affect Ms. Tinkersley at all. She gets out and she continues the same behavior. I mean, the last time she went to prison in 2020, it was a 3-year sentence. She got out and started the same conduct. She's a drug trafficker. Minimum sentence certainly is not warranted here. As the sentence of this court finding that the prison is consistent, the defendant is not amenable to community control sanctions, that on count 1, the defendant served a term in prison of 11 months. On count 4, she served a term in prison of 17 months, as we served consecutive to each other for 28 months in prison. She has 4 days of credit. Court finds consecutive service is necessary to protect the public from future crime and to punish the offender. They're not disproportionate to the seriousness of her conduct and to the danger she poses to the public, and her history of criminal conduct demonstrates that consecutive sentences are necessary to protect the public from future crime by the offender. She's been selling drugs for 15 years. She gets out of prison and continues selling drugs. And these are 2 separate incidents, and they deserve to be punished separately. I need to advise you upon your release, you may be put on post-release control for up to 2 years. If you are and you violate any of those conditions, the parole authority can send you back to prison as punishment for violating the rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of the term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as a part of the sentence at this time. Court disapproves the defendant's placement in a program of shock incarceration, intensive prison program, transfer to transitional control. I'll order the forfeiture of the contraband and instrumentalities set forth in the specifications. I will dismiss counts 2 and 3 as agreed to. I think that's it. Mr. Gagrich, anything else I'm going to omit or need to address?
Nothing, Your Honor. Thank you.
Ms. Tomazik?
No, Your Honor, thank you.
All rise.
Detective Warren Artherio Slappy Thrash, 25M608585. Did you guys resolve that? Am I going to look at that and have to quarrel with that? If I am,
I think you're going to be very happy.
good. Good. Do I have anybody here for Slappy Thrash?
Yes, sir.
Yes,
he's on Zoom.
Okay. How you doing, Mr. Slappy?
Pretty good. How about yourself?
Not too bad. Your name?
Warren Arterio Slappy Thrash.
Is Trooper Martin here? Thanks, Deputy. Trooper Martin here by chance?
Yes, sir.
Good morning, sir. Your name?
Trooper C. Martin, sir.
All right. Good morning to you, and good morning, Mr. Slappy. You're charged with 90 and a 70, 16 to 20 over. Do you care to offer anything here, Trooper?
I can give him 1 to 5 on the freeway if you'd like.
Listen, Mr. Slappy, can you listen to me, please?
Yes, sir.
They had you going back in February, 95 and a 70, and you outdid yourself in May by going 103 and a 70. Now, I don't know what you're doing. If you want to be a NASCAR driver, go into it. You can't be driving like a maniac down I-75 all the time. Why are you covering your mouth? You're going to laugh? I mean, I'm not trying to be funny here. I'm just telling you, you're driving like a maniac. Slow down.
I understand, sir.
Well, come on. I mean, come on. You're going to hurt yourself or somebody else. My Lord. I understand it happening. You just keep doing it. So you're good with 75 and a 70, Trooper?
That's up to you, sir. You have the final decision, but I'm good with that.
Well, I try not to get involved in their plea bargaining. What you guys offer or don't offer. Sometimes I'm not as good at that as I should be, but if you're good with it, I will do this. If you're not, just tell me. It's up to you.
Okay, that's good with me, sir.
You want to plead the 75 and a 70, Mr. Slappy Thrash?
Yes, sir.
I'm telling you, you come back in front of me, I'm not going to give you any breaks. Do we understand one another for speeding?
Yes, sir.
To the charge 75 and a 70, responsible or not responsible? Responsible, that's 0 points. It's going to go on your traffic record, but it's 0 points. You understand that?
Yes, sir.
Okay. How do you plead the 75 and a 70? Limited access.
Responsible?
I'll accept the plea. Dismiss the original charge. You're going to pay $210 on this. You can pay that today?
Yes, sir.
Mr. Slappy Thrash, I hope you're taking me seriously.
Yes,
Right?
sir. Yes, sir. And I also want to thank the trooper.
Yeah, I know. He's an awful nice man.
Yes, sir.
He's doing that. A lot of them wouldn't have done that. Lisa, this commitment doesn't have a signature line. I'm just going to sign at the bottom. They're not going to reject that, right? I wouldn't think. If you think it's a problem, when you see it, let me know, okay?
Oh, yeah, I'm
Jason-
sorry. There was a page 2. It's on the printer.
No, that's all right. That's all right. Trooper, okay, you're all set, Mr. Slappy Thrash. Good luck. Make sure you pay that.
We'll continue.
And I would like to speak
And
to.
I would just wish you happy birthday, but now you're
Thank
going to
you.
ruin that.
I'd like
Go
to
ahead.
speak to the matter of bond, Judge.
Yes, sir.
Your Honor, my client is 26 years old, no prior history, no prior felonies. He's had one DUI that was like 7 years ago, and that is the only thing that is on his record. This incident stemmed from a matter that happened back in February, January. There was in Canton. This stems from a situation that happened in Canton. My client cooperated fully with the authorities back then. When I say fully, I mean fully. He resided at the same place that when he was arrested back in February, where he got arrested, when he was arrested a couple of weeks ago. In July, when he tried to get some of his phone, his laptop back from the authorities in July, the officer told him then that they were still trying to investigate and charge him with the crime. He still didn't try to flee I'm trying to get to the point that he knew that something may be coming down the pike, but he still resided at the same location and didn't try to flee or anything. I believe the bond currently is $500,000, which might as well be $5 million. I would respectfully ask the court, based upon his non-criminal history and the fact that he did not try to flee, even though he was arrested back in February, was held for a few days. Is that correct? 3 days, fully cooperated with the authorities then, gave statements and everything. And a few months passed. And when he got his phone back or wanted to try to get his license from the police officers, the detective, they said, hey, we're still investigating. They're trying to charge you with this. Still resided at the same location. When they arrested him, he was at the same location. I would respectfully ask the court to give a more reasonable bond. I know the charges are serious. However, if Mr. Dabney would have wanted to flee, he could have done so for the past 7 months, Judge. He could be in Tahiti right now.
Does he have other felonies pending?
No, Judge.
No. Okay.
Your Honor, I would object. It's my understanding from Mr. Kennedy, as I'm covering this case for today, is that at the next PCC, it's our intention to amend the complaint to amend the charges and add charges of aggravated CSAM possession using a computer to commit a crime, as well as CSAM possession. In this case, it does stem from an incident in Canton where authorities were investigating a different individual. And in that investigation of that individual, they found a video on that individual's phone that had been produced in his basement with an individual on a video who resembles Mr. Alan Dabney sexually assaulting a child. Through that, they got his phone for this investigation and located an overwhelming amount of CSAM on his device.
On Mr.
Yes, and those images include images of children performing sex acts on each other, as well as being sexually assaulted by adults, as well as nude photos. And the report only just gives a small, preview of that. The report states overwhelming amount of CSAM on his device. So I have extreme concerns given that he was investigated for a video of him sexually assaulting a child, which then led to.
You gotta see now I like hold on.
Well,
she just indicated it
you
resembled.
need to not interrupt.
Okay.
She did not interrupt you.
She just
No, what did I just say?
I understand, Judge.
Go ahead, miss.
And then now they find all these other images and videos on his phone. So I have concerns, would ask that bond remain as set.
What I would like to object to was she indicated it resembles. they had 9 months to determine whether or not this was in fact that a person on the video. And now she's saying resembles, and then 2 minutes later she said it is him. I object to that mischaracterization, Judge.
And it was led to him, and then there's CSAM on his phone.
And just as I know it may not matter, but Mr. Allen Dabney was involved with this man in a romantic relationship, and this man that they found the devices, he had possession of his devices, of my client's devices. Sharik Alam, this person stayed in Canton. The authorities was led to this other individual's location. My client was involved romantically with this person that they arrested and charged back in Canton in February. As I already indicated, Yana, I understand that the charges are serious, but what I really do not like is that when she says resembles, that means that they don't know if it's him or not. And for the fans,
maybe that's the purpose of these proceedings.
I understand, but I don't like the fact that she said resembles and then says it's him.
That led to him, as I'm to understand, and that.
Yes, I'll correct what I said. If the report says resembles, we have to talk with Detective Morrison further to see what that video actually entailed, as it was just the first part of the report. So I'll correct what I originally stated. But that video did lead to them getting Mr. Allen Dabney's phone and locating voluminous amounts of CSAM on his device.
Anything further?
No, Judge. I just think that a more reasonable bond in this circumstance with no prior criminal history would be more like 100,000, 10%, Your Honor.
Well, given that if it was that individual, but then led to CSAM, which was on his device,
which was in the possession of his lover.
You want to? I'll let you go.
Oh, I'm sorry.
No, I'll let you go.
I don't have my robe on today.
I know you don't have one at all. And maybe you got to figure out who does.
I understand. I'm sorry. Get a little excited.
Because this is going to be a long hearing.
No disrespect, Judge.
Well, it was.
Okay.
Given everything that the court has heard, and further that there are additional charges, which I understand are coming in the case, the court does believe that the bond as set is appropriate. Motion for bond reduction is denied. Bond will continue.
Thank you.
Your Honor, just briefly, may I just respectfully ask for the 10% or no?
Bond will continue as set. Thank you.